Good morning, everyone. Thank you for joining us for the Medical Board of California's Quarterly Board Meeting Day 2. While this meeting is being conducted with participating board members and staff at the meeting location, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments for those who wish to speak will be heard for each agenda item from individuals attending in person and remotely. To be ready for remote public comment, we ask that you please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the devices you are connecting with has bandwidth limitations. If you have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application and then select Switch Audio. You'll see an option to call in and will be provided with a telephone number, access code, and an attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the View Additional Meeting Information link on the first page of the meeting agenda for more information on connecting to the meeting and accessing meeting materials. Thank you, President Lawson. You can now start the meeting.
Thank you, Sean. Good morning to board members and to those of you joining us here in the room and virtually. Welcome back to our second day of meetings for the Medical Board of California. I'd like to first ask us all to turn our phones and any other devices to silent. You may notice that board members are using their laptops, phones, or other devices during the meeting. They're using these devices to access board meeting materials that are in electronic format. If you're a member of the media and require assistance or information, please see Aaron Bone, right up here at the front. If this is an official business meeting of the Medical Board of California and disruptions of the board's business will not be tolerated, Government Code Section 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear a room if order cannot be restored by removing or muting the disruptive people. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. As Sean mentioned, this meeting is also being streamed via WebEx. Individuals attending the meeting remotely via WebEx will also have an opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating this WebEx event will activate the hand raising and Q&A features of WebEx and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment, but this time period may be reduced depending on the number of people who wish to speak so that more people may be heard. The host will audibly announce when 30 seconds remain to conclude the public comment. After the individual's time for public comment has lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. Today's meeting will be run according to the Open Meeting Act as required by law. We plan to end today by at least 3 p.m. I'd like to now officially call this meeting to order at 9:04 a.m. Ms. Struther, if you could please call the roll.
Mr. Arkatov,
Here.
Dr. Ayala Rodriguez,
Here.
Ms. Chung, here, Ms. Holmes, here, Dr. Mahmood,
Yes.
Mr. Portillo,
Here.
Dr. Solis, here, Dr. Thorpe, Dr. Tolbert,
Present.
Ms. Torres,
Present.
Dr. Sy,
Here.
Mr. Watkins, Dr. Yip,
Here.
Ms. Lawson.
Here. Thank you. A quorum is present. And I would like to remind the members again, we'll be taking a roll call vote on all action items. We are going to be doing some reordering of the agenda this morning to take some action items and accommodate schedules first. So we are going to be starting with agenda item 12, which is discussion and possible action related to the Midwifery Advisory Council. I think we have Ms. Weisner on the line. Confirmed? Confirmed.
Hello. Yes, you do.
Good morning.
Good morning, everybody. I am Madeline Weisner. I'm the chair of the Midwifery Advisory Council. The MAC meeting scheduled for January was unfortunately canceled due to a lack of quorum. So the upcoming meeting in April will include the agenda items the board previously approved. The MAC is also requesting the addition of one new item because 3 members' terms will end on June 30th of this year, and the MAC needs to select candidates to recommend to the board to fill those positions. The MAC requests a motion to approve the addition of the following agenda item for its next meeting on April 16th, 2026, which is a selection of 3 candidates to recommend to the board to fill 2 licensed midwife positions and 1 licensed physician position on the MAC. So I would suppose that following public comment, I would ask for a motion to approve the requested agenda item for the next MAC meeting.
Thank you, Ms. Weisner. Are there any questions or comments from board members? Okay, seeing none, are there any questions or comments from the public?
Yes, if anyone would like to make a public comment here for, agenda item 12, please do so by raising your hand now. I'll give you a few seconds to queue up. Not seeing any requests at this time.
Great, thanks, Sean. Okay, we'll bring it back to the board. Seeing no public comment. Can I have
I
a-
move to accept the proposed agenda items for the Midwifery Council meeting.
Great, thank you, Dr. Sy. Is there a second?
I second it.
All right, is there any further discussion? All right, seeing none, if Ms. Struther, if you could please call the roll.
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez.
Yes.
Ms. Chung.
Yes.
Ms. Holmes.
Yes.
Dr. Mahmood,
Yes.
Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Aye.
Dr. Yip,
Yes.
Ms. Lawson.
Yes. All right, that motion carries. Ms. Weisner, thank you for joining us this morning. We appreciate it.
Thank you.
We are now going to go back in time to agenda item 9. 9C, 9C.
Yes, members, good morning. We are on AB 1558. This bill would enact the Uniform Emergency Volunteer Health Practitioners Act, which is a statute that has been enacted in 19 other states and is based upon the work of the Uniform Law Commission, which is a nonpartisan organization that drafts and recommends that the states throughout the country adopt various laws on a variety of topics on a uniform basis. This proposal is intended to speed up the deployment of volunteer licensed healthcare professionals from around the country to areas of need following disasters of various types. It appears to authorize volunteer registration systems to deploy providers licensed in other states to do their work in disaster areas without prior explicit government approval. This is an area of the law typically handled by the Emergency Medical Services Authority, although it is on our agenda today because the bill includes some language related to the various health licensing boards. First, it authorizes a board to establish one of these volunteer registration systems. Second, it provides a measure of authority for a licensing board to regulate a volunteer health practitioner who is practicing here under this proposal. As discussed on page 4 of the analysis, the board staff have identified a number of areas where we believe the language may be unclear, and the last several bulleted items on that page relate specifically to regulating health practitioners. We do not have a staff recommendation for a position on the bill, and at this point are seeking comments from the board that are in addition to or may differ from the staff's comments in the analysis. If the board is agreeable with the staff comments, we'd be happy to attempt to work with the author and sponsor to gather additional information, address any concerns, and then report back at the next board meeting. Happy to answer any questions.
Thanks, Aaron. Questions, comments?
Public comment?
I have a question.
Dr. Sy.
I didn't see any time limit, or did I miss it? Is it just a blanket emergency? You can help out for X amount of time, or is there a defined like 30 days, 90 days?
I believe it's intended to cover during the duration of whatever the emergency declaration is.
Okay, so that's defined by the governor's office.
By the relevant declaration. Yeah, potentially, definitely the governor. Not sure how this might interact with presidential
Uh,
disaster declarations. This is something that still working to gather a lot of the details about how this would work, how this would fit in with. There's an existing emergency services compact that I believe every state has entered into, and that's authority that I believe the administration used during the COVID pandemic. And there was some authorization through EMSA, the Emergency Medical Services Authority, to provide some opportunity for out-of-state providers to come here into California to practice without going through the regular licensing process here.
okay, thank you.
Right. If there are no comments or questions, we'll go to public comment. Dr. Yep.
Yeah, I agree with the board staff analysis. There are a lot unknown here, so I think need more work. Thank you.
Great. Public comment. Any public commenters in the room on this bill? Sean, are there any public commenters online on item 9C?
Anyone like to make a public comment for AB 1558? Please do so by raising your hand now. Give you a few seconds. First up here, we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, good morning. I know we're not allowed to ask questions, but just some thoughts then at random. You guys are going to develop this through that horrific form system you have. I just forget the name. That thing you use make a complaint form out of. I mean, and why? I mean, every board has one. So, so all the different medical boards are going to have separate forms. And is there data definition? I just, it's weird. And whoever, I didn't read the staff report, but whoever said, your time, as you know, that's absolutely central. I think it's ridiculous that you work for free. It's insulting us. It's making the job bad. It's bad in every way. So yeah, why should you do more work? And I just don't understand the whole thing. It should be better defined. So whatever you can do is fine. But it sounds pretty weird having something that disorganized and you doing independent forms for something that is a statewide emergency. But okay, so go ahead. Thank you. I'm done.
Thank you for your public comment. This time I do not see any additional requests in queue.
All right, we'll bring it back to the board. This is not an action item because we were just providing comments, correct?
If you would like to move the staff recommendation to direct us to provide the comments that are noted in the analysis, then we'd be, and that's approved, then we'd be happy to
That
do
sounds
so.
like a great idea. Would anyone like to make that motion?
I'll support that.
All right, motion from Dr. Mahmood, and I'll take that as a second from Dr. Sai. Have a roll call vote on that.
Mr. Arkatov.
Yes.
Dr. Ayala Rodriguez.
Yes.
Ms. Chung.
Yes.
Ms. Holmes.
Yes.
Dr. Mahmood.
Yes.
Mr. Portillo.
Yes.
Dr. Solis.
Yes.
Dr. Tolbert.
Yes.
Ms. Torres.
Yes.
Dr. Sai.
Yes.
Mr. Watkins. Dr. Yip.
Yes.
Ms. Lawson.
Yes. All right, that motion carries. We will move on to agenda item 9I, I believe, SB 849.
That is correct. This would require the board to automatically revoke the license of someone who was previously revoked by the board for specified acts of sexual misconduct with a current or former patient or client, or due to a conviction of specific criminal sexual acts, and the individual's license was reinstated by the board on or after January 1, 2020. Those subject to the bill would also be ineligible for reinstatement. The bill is authored by Senator Weber Pierson, who is a physician licensed by this board and is certified in obstetrics and gynecology. AB 849 follows up to the senator's prior legislation in this area, AB 1636 from 2022. That prior bill included 3 key law changes. It extended the board's authority to deny issuing a license to someone with a history of sexual misconduct. It required license revocation for those convicted of certain sexual crimes. And lastly, it barred from reinstatement someone whose license was revoked or surrendered due to their criminal, sexual, criminal, or professional misconduct with a current or former patient or client as specified. The analysis includes some excerpts from the author's fact sheet that describes the senator's intent, including that the physician-patient relationship involves significant vulnerability and requires ethical judgment and integrity. Further, the senator points out that the serious physician misconduct calls into question their ability to safely care for patients. It's possible we'll be hearing from a representative from the senator who I hope will be able to address the board during public comment. Based upon prior legal history in the area, staff believe that the approach proposed by the bill could subject the board to legal challenges, possibly at a major cost. Further, when a plaintiff is successful in their litigation against the board, there is a further risk that the board will be required to pay legal expenses to the plaintiff on top of the board's own legal expenses. As an alternative to the current approach in the bill, staff are instead recommending that the board request amendments that would replace all the existing content in the bill with statute changes that would do the following. First, strengthen existing laws that prevent issuance of a license to an applicant who has committed criminal sexual offenses in or outside California, including for the commission of crimes that have been dismissed or expunged following a conviction. Second, mandate license revocation for a licensee who is found by the board to have committed any act of sexual misconduct or sexual exploitation with a current or former patient or client. Third, prevent someone from seeking reinstatement if their license was revoked or surrendered by the licensee while a board accusation was pending against them due to any act of sexual misconduct or exploitation with a current or former patient or client. And finally, prevent someone from seeking reinstatement if their license was revoked because they were convicted of a crime that requires them to register as a sex offender regardless of their relationship to the victim. Also establishes a similar requirement for sexual criminal offenses that occurred outside of California. Accordingly, staff recommend the board adopt a support if amended position and replace it with the language that's just shown on pages 4 and 5 of the analysis in the underline and strikeout. Happy to answer any questions, Madam President.
Thank you, Aaron. Questions or comments from board members? Dr. Mahmood?
Yeah, well, it's very interesting. I mean, you already brought it up that people who have been already indicted are prosecuted, and now they have already reinstated the license, and getting their license revoked now after being reinstated is going to open up the whole Pandora box. So, is there going to be any more requests for amendment that started from now and leave the things behind, so that we don't have too much litigation there? Board is going to incur so much cost on this if people start suing us. And or how many people we have actually on number who are in this situation?
Yeah, so we've had numerous conversations with the author's office, expressing, concerns with the approach, and talked about risks, and there's that, the board has in the past, had to provide legal expenses when the plaintiff has prevailed against the board. So we've done our best to make that clear to them, and that's further, illuminated, in the analysis, and had very positive, very productive conversations with the author's office. And so, and have shared this, with them, so they're aware of what the staff are recommending, and, look forward to talking with them further, of course, depending on the board's position today.
And just to follow up, and also the extent of the offense, especially we are living in the world of, I hate to bring this up, political thing, Epstein files, and we don't know how many more people will come, and what the extent is going to be, and how the charges are going to be, and how people are going to take advantage. I mean, this is a really very complex situation.
Yeah.
Other questions or comments? Mr. Portillo?
So on the current bill, does it apply retroactively as currently written?
Yes, that's the intent. Yeah.
Okay. And then subsequently, I saw that we were saying, notwithstanding that they're going to be denied the license, even if it was, something that was dismissed or expunged.
Yeah.
So does that, if someone, let's say, had their conviction overturned because they determined it was wrongfully convicted, would they be able to get their license back, or would this still prohibit them that? Because at one point they were on the list.
Maybe I'll let Ms. Webb respond to that. Thank you.
If the conviction is actually overturned, then this would not apply. But if they're able to get it expunged, the prohibition would apply, because unfortunately, sexual misconduct cases are remarkably easy to get expunged. And then there's another statute that prevents the board from considering an expunged conviction even for sexual misconduct, and we want to change that.
And the context is in an application. So somebody who's maybe coming in from out of state, or, is otherwise newly seeking a license here for the first time.
Other questions, comments, Ms. Torres?
Just one other comment. I mean, I see here too that it looks like a plea of nolo would constitute a conviction. And I just, there's a lot of folks that, may not think of themselves as guilty, right? But don't want to go through a trial, right? And so decide to plead nolo. And so I think that too is a little bit of a concern, because I think you'd, to have somebody plead nolo contender and then have it be deemed a conviction, I think opens us up to further legal challenges, especially if it's retroactive.
Staff's proposal would not be retroactive. It's forward looking. And so people, have the opportunity to consider that. And the conviction after nolo plead, that's consistent with our other statutory language. And so, someone who wants to be in the medical profession needs to think about how they proceed. But, we think it's important to draw the line here.
Other questions, comments, Dr. Tsai?
Yeah, per staff's recommendation, strengthen existing legislation or laws to prevent applicants from being able to obtain a license. Is that something that is currently in the books, because you're saying strengthening?
Yeah, so there is, this existing code section so if you look at page 4, that BPC section 2221, that is a code section that is particular to physician applications. There is, in addition, a more general code section, BPC 480, that also has application to the medical board. That code section generally states that 7 years is the maximum look back period that a licensing board can have when they are considering an application in somebody's criminal or professional discipline. There are some exceptions to that, serious and violent felonies, and there are some existing law language within BPC 480 that also deals with discipline in another state with respect to sexual misconduct. That was one of the elements that was in AB 1636 from a few years ago. So it's tough sometimes when you've got multiple statutes that are working in the same area. Ms. Webb?
Yeah, I'll just add that the prior bill gave us additional tools if the person committed sexual misconduct with a patient, but we're saying if they have to register, if they're convicted for sexual misconduct with anybody, we want to stop it.
Right.
Want to stop them from getting a license.
Any additional comments, Mr. Watkins?
More a comment than anything, because I find it strange that the retroactive application of this, it almost seems like out of place, because everybody knows in the law that to try and go retroactively with something is going to be a difficult journey. And I just don't understand. Maybe that is my question to the Senator Weber, is why was it, it almost seems like a reactive statement instead of looking like, okay, this wasn't covered in the 4th previous bill, let's just move. So that's more like the question. If it's so obvious, why is it in the bill? Because it's almost like a disqualifier already.
maybe they'll be online and they'll be able to respond to your question, Mr. Watkins.
All right, well, if there are no further comments, let's open it up for public comment. Anyone in the room? Thanks for coming back for day 2.
Always. Hello, my name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA sponsored AB 1636, which ensures physicians convicted of sexual assault with a patient lose their license with no ability for it to be reinstated. CMA also supports SB 849, which will allow for the implementation of AB 1636 as the author intended. CMA appreciates your thoughtful consideration of this bill. Thank you.
Thank you. Anyone else in the room for public comment? Sean, if you could open it up online.
Yes, if anyone would like to make a public comment here on SB 849, please do so by raising your hand. Calling you in the order we see them. First up here, we had Eric Andrus. Eric, you should be receiving that prompt. All right, Eric, the line's open. Eric, I saw you come off mute, but we're not hearing you. Circle back to you in just a minute, okay? Next up here, we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, I wasn't going to comment on this. In fact, I wasn't even coming here at all today, but I'm kind of concerned about you guys now prying into, I can't even say the word, expunged records. You did that to me. I spent a year of my life on a false accusation, very similar to the one Joseph Sepulveda launched against me. I mean, even worse in a way. I had to stand up to the San Diego Police Department for a year, telling them it was a false accusation. They eventually backed down, which police do not do easily. You guys think you were tough? They backed down and they got a certificate, something called a certificate of factual innocence. Well, when you decided to whatever the word is, convict, charge my real psychiatrist with whatever gross negligence for it was an ADHD trial. The other person, trans woman who committed suicide, was also had ADHD. That was the only thing they had in common. But we talk about different professions here. They seized Dr. Urbe's notebook, which had that. I explained the situation there, and a journalist, you imagine a journalist giving up his notebook.
Mr.
Dr.
Gordon?
Urbe sang like a canary. Anyway, you are people need to be warned about what you're doing. If you're opening up old records, I just something just connects wrong with this whole thing. Thank you. Go ahead.
Thank you for your public comment. Gonna try you again here, Eric. Let's see who's sending you that request.
Can you hear me?
Yes, we can, Eric. Yeah, please go
Okay,
ahead.
good, thanks. Gee, Christina, you welcome the CMA back, but I've never heard you welcome patient safety advocates back. That truly shows your allegiances, doesn't it? So let me get this straight. Did I hear this right? Dr. Mahmood is more concerned about legal costs to the board than protecting patients from sex offending doctors? Dr. Mahmood, do you think that's fulfilling your duty to the board to protect patients above all else? Patient safety always takes precedence, not worrying about the board having legal costs. Nowhere in the board's mission statement does it mention the board's finances over patient safety. And this in and of itself, this attitude of some board members, I think clearly shows why there's so little patient safety actually going on. It's funny that Senator Weber has written another bill when not all that long ago she got the facts wrong on her last health bill and the board had to correct her. So I think you need to be careful going forward working with Senator Weber on bills like this. Thank you.
Thank you for your public comment. Last up here, we have Marion Hollingsworth. Should be receiving that prompt.
Hello, can you hear me?
Yes, we can. Please go ahead.
Okay, thank you. Good morning. This is Marion Hollingsworth, patient safety advocate. It's rather sad that this board is more concerned about the cost of defending themselves in lawsuits with this legislation than they are about protecting patients, This underscores the fact that you really do want to protect the profession more than patients that you have sworn to protect when you took your oath to be on the board. Is it more important to have a sexual offender remain in practice so you don't have to spend money to defend the board? You should know that Dr. Akilah Weber was unclear about her first bill, 1636. About a year ago, she told a reporter that if a doctor had a sexual misconduct discipline or investigation, they could not have their licenses renewed. This is not true, as you know. So perhaps this bill will fill in the holes that 1636 left. Granted, making this bill retroactive is more unconventional, but since this board is traditionally lenient on doctor disciplines, 849 might further protect patients. I urge you to support this bill to further protect California consumers from predatory doctors. Thank you.
Thank you for your public comment. This time, there are no additional requests in queue. Last public comment.
Thanks, Sean. All right, we'll bring it back to the board. Any additional comments? Someone want to move staff's recommendation? Thanks, Dr. Mahmood. Thanks, Dr. Yep, we have a motion and a second. Any further discussion? All right, seeing none, Ms. Struther, could you please call the roll?
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez,
Yes.
Ms. Cheng,
Yes.
Ms. Holmes,
Yes.
Dr. Mahmood,
Yes.
Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sai,
Yes.
Mr. Watkins,
Aye.
Dr. Yip,
Yes.
Ms. Lawson.
Yes. All right, that motion carries, and we are going to move on to SB 903, Agenda Item 9J.
This bill places restrictions and prohibitions on licensed healthcare providers who would use artificial intelligence or AI in the course of providing therapy or psychotherapy, which this bill defines as diagnosing, treating, or improving a patient's or client's mental health or substance use disorder condition. Though the services are most commonly provided by those regulated by the Board of Behavioral Sciences or the Board of Psychology. However, the definitions of therapy and psychotherapy make it clear that the bill applies to physicians. SB 903 is modeled after legislation enacted in the state of Illinois last summer, and when providing the specific services I described a moment ago, this bill would prohibit a licensed health professional from using AI to, 1, make independent therapeutic decisions, 2, directly interact with clients in any form of therapeutic communication, unless they are using a product that is approved by the US FDA and is HIPAA compliant, 3, generate therapeutic recommendations or treatment plans without review and approval by the licensed professional, or 4, detect emotions or mental states. If the provider gets appropriate patient consent under this bill, they could use AI to provide what's referred to as supplementary support. And examples include preparing and maintaining client records, analyzing anonymized data, and identifying and organizing external resources for their clients' use. The section of the analysis titled Consideration of a Board Position includes a variety of staff comments about the current language of the bill. Portions of the bill reaffirm existing law relating to patient privacy and the unlicensed practice of medicine, notably not using AI to make independent therapeutic decisions. We have also pointed out various concerns with the language, including that some terms are vague and possibly overly broad. The bill seems to state that the provider using AI maintains full responsibility for all interactions, outputs, and data use associated with the AI system. If you have multiple providers using one system, then it raises the question of who is that person with the full responsibility. Such a requirement may place a significant challenge for a provider to take on in the course of their work. Further, this proposal is modeled after legislation that was signed into law about 7 months ago. So therefore, it may be difficult to state that enough time has passed to understand how that law is impacting the residents and healthcare providers in the state of Illinois. Finally, the bill states that violations will be enforced by the California Department of Consumer Affairs, which is contrary to how enforcement is currently handled by the various boards. Staff do not have a position recommendation, as this is the first bill, I believe, to be discussed that attempts to address the clinical uses of AI. Hopefully, we will have representatives of the bill sponsors to provide public comment. The board has options. You could take a position today. You could direct staff to send a comment letter to the author, or have us monitor the bill and report back at the next board meeting. Maybe a bit of all three of those things. Happy to answer any questions, Madam President.
Thanks, Aaron. Questions, comments from board members? This one seems complicated. All right, let's open it up for public comment. Anyone in the room? How about online, Sean?
Yes, if you'd like to make a public comment about SB 903, please do so by raising your hand now. First up here, we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, just get rid of this. Don't do anything. There's too many problems with it. A couple comments though. There is nothing magical about diagnoses. Anybody that can do it. And you guys made a good finding yesterday with that records, that there's a law that anybody can just put crap in your records. They can put diagnoses in them too. And by the way, that guy that psychiatrist that freaked out that I said the word retaliation, watch out for diagnoses. They're transferable. Apparently you're not listening, so I guess you're talking around. I guess I'm used to that. But the second thing was HIPAA. It's so funny. I'm talking to bobbleheads and they're even talking. HIPAA is 100% fraud. And I don't make comments like that very often, but you guys have a 3% chance of a successful outcome when you interact with your agency. Theirs is 0.007, infinitesimal. It's impossible. They do nothing except send Congress a bill every month saying we need more money. So they trick even more people than you. Just HIPAA's fraud. It's fake. It's fraud, and that's a definitive statement. So anyway, anything that's HIPAA in it, I forget. And anyway, this bill's a mess. Don't vote for it. Thank you.
Thank you for your public comment. Next here we have Tyler Rind. Should be receiving that prompt.
Good morning. I'm Tyler Rindy on behalf of the California Psychological Association. We are one of the co-sponsors of SB 903 alongside the California Behavioral Health Association, National Union of Healthcare Workers, and California Association of Marriage and Family Therapists. Appreciate the discussion this morning and look forward to hearing more about the discussion of the bill. Appreciate the staff analysis and thoughtful staff comments. This bill was adapted from the Illinois law that was passed about 7 months ago. There is still a lot of technical details that need to be worked out with the language to adapt it to California. So we've been hearing a lot of discussion and wanting some clarity on certain things. We're, on behalf of the author's office, we are very willing to work on a lot of these things. So look forward to your feedback. And hope that at some point we could get to a point where the medical board could end up supporting the bill. Just as context, the Board of Psychology last week at their meeting did vote to support the bill. And I know that the Board of Behavioral Sciences is considering the bill pretty soon. So just hope, to work on some of these issues that you all have identified around the scope of it and some of the more vague language that needs to be clarified. And also I recognize the challenge that the bill right now puts most of the onus on the provider, but these tools are being developed by AI companies, and it needs to be either a shared responsibility or something that the providers are not the ones that have the ability to, see what the challenge, or they don't have the full responsibility of what the tools are. So look forward to the discussion. Thank you for discussing it today, and hope we can get to support it some point on the bill. Thank you so much.
Thank you for your public comment. At this time, there are no additional requests in queue.
Thanks, Sean. We'll bring it back to the board. Questions, comments? Dr. Mahmood?
I would say that this is still unfolding and it's a little complicated for us. Maybe I would suggest we explore more and bring it back to the board for discussion again. That'll be my motion if it's the right thing.
Sounds good. Thank you, Dr. Tolbert.
Yeah, I agree that it doesn't feel like we know enough about the effects of the bill that was passed in Illinois and how it's going to play out, how it's playing out. The bill feels broad. And AI is, as we all know, is a rapidly changing and changing environment. And so what are the downstream consequences of this? And oftentimes providers are not necessarily the ones that are the drivers of a system. So, a health system is or decides to adopt. So how would that interplay?
Thanks, Dr. Tolbert. Other comments, questions? It sounds like we want to, I guess, adopt staff's recommendation to continue working on this. Does that sound right?
It sounds great. That sounds great.
Do we need a motion to do that? I don't
Yeah.
think so.
We have the staff comments.
Right.
And so that's a foundation plus the comments of the doctors. And we'll learn more. Appreciate that the sponsors are online, and we'll do our best to chase down more information and report back at the May meeting.
Sounds good. Okay, moving right along. I think we are taking agenda item 9K, SB 1002 next.
This is our final bill, which expands an existing law that allows certain out-of-state physicians to treat a patient in California via telehealth for an immediately life-threatening disease or condition without a medical license in this state. Under SB 1002, the patient could continue to see that physician if their qualifying disease or condition is in remission. This bill is a reintroduction of SB 508 from last year, which the board opposed, as the board views the requirement to obtain a license to practice medicine as a key consumer protection. After SB 508 was approved by the Senate, it was then amended to instead now address the California Environmental Quality Act. I met with the author's office early last week, and they expressed their desire to collaborate with the board to identify amendments that the board might support in order to facilitate patient access to high quality out-of-state physicians who can treat patients with these challenging conditions. The board staff do not have any suggestions at this time for the board to consider on amendments, but if the board does have any, we could certainly incorporate those into a position or some other discussion with the author's office. If the board does not believe that any amendments can resolve your concerns, then adopting an opposed position would then be appropriate. I'm happy to answer any questions.
Thanks, Aaron. Any comments or questions? Dr. Mahmood?
So how would we, if we just give the exemption for doing the tele license, how would we know that practitioner is actually qualified, and state of California would know and would be able to protect our consumers if we have just exemption for somebody? And every state has different standards, different level, and this might open the Pandora box for global things too. So we need to have some kind of criteria where we think whoever is providing advice, or treatment, or follow-up meets a requirement to be able to do that. So is there anything in that, or it's just like, okay, he has a license somewhere, he can do it?
So the existing law for this current licensing exemption that's on the books right now defines an eligible physician and surgeon to be someone who is licensed in another state in good standing and has no history of prior discipline, and their medical expertise is that of the eligible patient's illness. So that's the criteria for what physician could qualify for this exemption for practicing in wherever state. But I think to your point is that there's no application to this board. There's no vetting that we would do. We don't know who's practicing here if they don't have a license, because they don't need to inform us, and we don't track things that aren't informed.
Exactly, that is the main concern.
And I want to say, more importantly, we won't have jurisdiction over that physician. So if there is a complaint about quality of care or other unprofessional conduct, this board could not take action against that physician.
Exactly, and it will directly put our consumers at risk without any accountability. I mean,
Other comments, questions?
I think
Ms. Holmes?
Do other states have this? I mean, is this just a California thing, or like, could you be a physician? Does Illinois have it where California can go in and provide services without a license?
Yeah, I don't have the full landscape. There are other states that do handle telehealth in different ways. I think some have reciprocity statutes, or others have like a registration that you can do, kind of like a light licensure process, if you will. I don't have the full landscape though with me, unfortunately.
And especially for the benefit of our new members, there is a statute that permits a physician licensed in another state to consult with a physician licensed here. But the point is the physician who's licensed in California is the primary, so that the board has jurisdiction. But they certainly can communicate with experts out of state.
And the experts out of state can also get a license with this board on their own.
Mr. Tolbert?
I would have a lot of concerns about this. That being said, I do think that if someone is really in an immediate life-threatening situation where they need medications or of whatever type, then the doctor that's out of state, because they know them, and if they meet the criteria, it seems reasonable for maybe a short period of time that they would be able to perhaps prescribe or what have you. That seems maybe reasonable.
Well, the existing law allows already for someone to receive care in these circumstances, but then once their condition goes in remission or is relieved, or it's no longer becomes life-threatening, then the exemption window closes. And so they're trying to extend this out, like for follow-up care and what have you.
So, yeah, I'm concerned about that.
Yeah, just to add, not to debate you, sir. Yeah.
Additional comments or questions? And I think I probably made these same comments on the prior bill that we opposed. I mean, this is something that needs to be solved with some sort of coordination and collaboration at a national scale. I know FSMB has some ideas about that, but I think we should think about how we can be part of that solution, because these things are not going to go away. And it is a slippery slope. So, and we talked about that last year with the bill, saying, well, if this happens, then we're going to get another bill that expands it a little bit further. And then we're going to get another bill that expands it a little bit further again. So I do think that we should be working with FSMB or others on how we're going to solve for this comprehensively, because it is true. People want to be able to see, get the best care for themselves wherever that care is located. And we've created systems, telehealth, other systems that make that accessible and easy to obtain in a way that 20 years ago didn't work. So our licensing, our systems need to adapt to 2026 and beyond also. Okay. Public comment from those in the room. How about online, Sean?
Anyone would like to make a comment here about SB 1002, please do so by raising your hand at this time. First up here, we have Eric Andrist. Eric, you should be receiving that prompt.
Can you hear me?
We can, Eric. Please go ahead.
Okay, so the way I understand it, the key to this bill is that patients can't get care in California when they need it. Someone mentioned yesterday that doctor volume in California is dropping, which is going to make it even harder. The board is only worried that they would lose the license fees from out-of-state doctors. Patients being harmed can file medical board complaints in the state where they received the care from the out-of-state doctor. So it's not like they can't get help if they're harmed. So again, think about patient safety, not about whether the California Medical Board gets licensing fees or has controls over the complaints, which you're throwing away by the tens of thousands anyway. If a patient is harmed in California, the likelihood of them getting help from the California Medical Board is next to nil. So why would you worry about whether they can get help for disciplining in other states? You guys aren't doing anything for us. So let us try it in another state. Why are you worried about it? The only thing I can see you're worried about is losing the licensing fees. Leave it to a patient who needs the care, not the state. Thanks.
Thank you for your public comment. Next here we have Robin Claw. Should be receiving a prompt on your end.
Great. Hi, can you hear me?
We can. Please go ahead.
Good morning, everybody. My name is Robin Clow, and I'm a member of the California Senior Legislature and submitted this proposal to Senator Niello. A little bit about me. I was wheeled into the operating room for scheduled thyroid surgery expected to take 3 hours, but 9.5 hours later, I was wheeled out to discover that my life would be forever changed. I was diagnosed with anaplastic thyroid cancer with the typical survival time for 4 to 6 months. And at that time, my daughter was expecting our first grandchild. I underwent 7 weeks of radiation and chemotherapy at Cedars-Sinai in Los Angeles, which I love. When the cancer returned, my physician supported my decision to seek care at MD Anderson Cancer Center in Houston. I received a newly developed targeted therapy that has been successful for me. One of the few specialists in this disease was at MD Anderson. It is uncommon for a bill to undergo a test run in public before enactment, but this is true of SB 1002. The pandemic led to federal and state executive orders that allowed telehealth visits, enabling doctors and patients to communicate about health issues across state lines. These executive orders have since expired, leaving patients like me without access to life-saving expertise from oncologists practicing outside of California. There are times when I've been too ill or weak to travel, and I'm immunocompromised and at risk or illnesses. So telehealth visits are truly a lifeline. Patients in my anaplastic thyroid support group are desperate to receive care from oncologists outside California when needed. With the projected shortage of doctors, telehealth visits will become even more crucial. So please allow Californians struggling with cancer to receive the care they need. I implore you to support SB 1002. It's a compassionate bill. In the meantime, I've survived 3.5 years, and now I'm not only having a grandson, but a granddaughter. Thank you very much.
Thank you for your public comment. Next here we have Jean Dorio. Should be receiving that prompt.
Can you hear me?
We can. Please go ahead.
Thank you, Sean. Hello, Medical Board. My name is Jean Dorio, and I'm a geriatric physician practicing in Santa Clarita, providing medical care to my community, including house calls for almost 40 years. I served as president of the Los Angeles County Commission for Older Adults and now sit on the California Senior Legislature. As discussed yesterday during your meeting with Frank Myers from FMSB regarding the role of AI, it is inevitable that evolving technology and open access to medical experts across state lines will be achieved through bills like SB 1002, as they were through executive orders during the pandemic. California must lead the way in helping residents access the best medical care available, even if it is out of state. SB 1002 may require thoughtful amendments to address any concerns you have, and even serve as a template for other states. Please support SB 1002, which would be a lifesaver for many Californians. Thank you.
Thank you for your public comment. There are no more additional online requests, but we have one more in room.
Hi, my name's Wendy Connect, and I just had an idea. I was thinking maybe there's a way that the board could establish a procedure whereby doctors could register similar to how lawyers do for ad hoc vice, so that they would be established and you would know that they were acting in that position, and then you could have jurisdiction over them. Just an idea.
Thanks, Wendy. Any other comments in the room? And Sean, I think we're done online, right? Yeah, I guess, I mean, I want to acknowledge the commenters and acknowledge Misconnect's idea as well. I know that we've taken a look at the Interstate Medical Licensure Compact in the past. That is one of these organizations, and the compact itself, the agreement that is coordinating licenses amongst states. We're one of a handful, maybe more than a handful of states that are not participating in that compact for whatever reason. I think it's something we should take another look at, because these issues aren't going away. And that allows for, my understanding, my lay understanding, of the compact allows for expedited licensing for qualified physicians across jurisdictions. I know there's a lot we would need to look into for that, but we're going to keep seeing these bills. And it is, I mean, exactly what the woman who was talking about, her experience with MD Anderson, that's been my own personal experience with my children, seeking care for them from Cleveland Clinic and elsewhere. You go to find the best care and you want to be able to continue those relationships. So I'd like us to be proactive about this rather than just reacting as these bills continue to come up, so we can figure out how to add that to a work plan or what have you. But this issue is certainly not going to go away, and we should be a leader in trying to solve for it. Dr. Tsai?
Yeah, I completely agree. And listening to public comment, if we carve either legislation or regulation specific enough, we won't provide a loophole for people without licenses practicing in California. You know, we want to make it so that instead of Californians flying to Texas for an office visit, this would be the same thing, telehealth. I mean, how is that different from, you know, you getting on a plane and flying to Texas? I think that would have tiered healthcare. If you're able to fly, then you can go see your doctor. If you're unable to fly, oh, well, you have to stay in California. So I think this is very important as technology, AI, all this is going to come at a crossroad, and we have to be in front of this, as our Madam President said.
Additional comments, questions? Dr. Yip?
It's certainly an area to explore with AI, telemedicine, and expert in the country and all that. It's go beyond just the licensing, go beyond like dispensing medication, like target therapy, how to continue care and teamwork and all that. And certainly with the whole open-eyed and look into more details and maybe in the future we have more appropriate plan to suggest to the legislature too.
Mr. Portillo.
Yeah. So the bill as currently written doesn't have a expiration date by which, you know, I guess the treatment and therapy can continue indefinitely, right? At least that's the way I'm reading it. Is that correct?
Yeah, it allows them to continue to have follow-up care, continuing care, even though the emergent life-threatening condition is in remission. So there's no time limit here.
So I guess that's, you know, I'm curious as to how, not just the medical board, but how other healthcare licensing boards are dealing with it. If you have therapists who are operating across state lines, you know, I think that a good point's been raised that how are we dealing with telehealth, and should that be required, you know, licensure and some of those other things? I think it would make sense for us to get ahead of that.
So good comment. And then Ms. Holmes, after your comment, Mr. Varghese found a map that shows kind of at a high level the landscape, and it looks like there's about 8 states that have registration waivers or some sort of certificate requirements for telemedicine. Looks like 9 jurisdictions have a specific license or permit for telemedicine. Several have regional reciprocity. So it looks like some of the Northeast states allow folks, you know, we got a lot of states that are very, you know, close to each other, right? So anyway, it's difficult to interpret this on the fly, but we'll be happy to share this with you.
I think that, again, this is where we can offer some leadership. When's their sunset review year? Next year?
Next year, we'll be working on a report later this year.
So we'll be working on that report later this year, and it would seem to me that this is an issue we could raise and talk about and propose some real solutions, options to the legislature for. I mean, I guess just to ground this back in the agenda item, which is this specific bill and a staff recommendation to oppose, I agree with the recommendation in that, I mean, we can't protect our consumers right now. There's no way to have jurisdiction over these physicians that are practicing. We won't even know if they're practicing in our state, right? We'll have no idea. And, you know, to Eric's point, while in the comment, while they certainly can file a complaint elsewhere, if they're located in California and receiving the care here, I'm not sure that other jurisdiction will necessarily have jurisdiction over the care that's being provided physically here in California. So I think it's just complicated,
Yeah.
which is why it speaks to the need for a broader solution to allow patients access to the care they need wherever that care actually is. So I agree with staff's recommendation that we oppose the legislation. Carrie, did you have a comment?
Yeah, I just, as we're thinking about this, we need to remember too that this would be an exemption for anyone. They're talking about the best of the best providing care.
Of course.
But the exemption wouldn't be limited to the best of the best. It would be for anyone, and they can take advantage of patients with their recommendations. You know, they can sell directly their special solution. And so we have to think about that as well.
Yeah, that's a really important point.
And
Dr. Miller?
and it's going to open something, not only the best of the best. Some patients might have preference for somebody and who has got a completely different way of treatment, which is not even probably authorized in California or United States. And they will be doing all this stuff and we won't have any accountability on them. It'll be a problem.
Yeah. All right, we're, Ms. Holmes.
Do we have to oppose, or can we just give them this feedback and see if they can amend?
It's the board's discretion as to what position to take. So no, a position is not required.
I think a dialogue to let them know of these concerns is important. So I would certainly recommend that. I imagine you could oppose now if you need to take a position, but
I'm sorry, I didn't catch that last
I
part.
imagine you could oppose now if you need to actually take a position, but you're telling me we don't.
No, the board has a free hand in terms of what positions it takes on legislation. And, and we've had other bills that we discussed on the agenda where we didn't take a position and we said, well, we have comments to make. And
So I think the collaboration should, considering that the chair is asking us to look at this deeper going forward, now's the time to start, is in my view. So let's maintain that dialogue. Let's open it and continue.
Thanks. Other questions or comments? Portillo?
Yeah, I would recommend, stay off of it for now. I would say if we can bring it back at the next board meeting in May, at that point, the bills are still, the House of Origin deadline hasn't passed. I would say we want to weigh in by for sure at one of the policy committees. So if it gets out of policy committee, I think, by that point, we'll have a better sense as to what the bill's looking like. And hopefully we'll have gotten a chance to better refine our position on telehealth and what best practices should be going on.
Yeah, by the time the May board meeting rolls around and we take a position on this, the bill would essentially be through the first house at that point. And so, but we'd have opportunity when the bill gets to the assembly. And this is the same bill that was approved last year. So I have full confidence that the bill will be approved in the Senate because it's the same language that they approved in that prior bill last year. So assuming the author wants to proceed, I expect it will be approved, and then we'll have another bite at the apple, if you will, in the assembly.
Did we have a position on it last year?
It was opposed.
Yeah.
Yeah.
I think my recommendation is that we continue to oppose and we tell them clearly we think there's a better solution. This is not the way to, but legislate in this area. We'd like to work with you collaboratively on what the next solution is, because it's this incrementalism and this lack of jurisdiction is really quite concerning. And at the same time, we want people to have access to care, and we should figure out how to make that happen. I don't know that we'll be able to be back by May with some comprehensive solutions. And I do think that's something that's more appropriate for our sunset review report, where we have time to dive into an issue and propose solutions, and then have a hearing set around all those.
Perhaps some ideas will emerge on a narrowing of the bill or adding some additional conditions, but
perhaps the bill can direct us to study at the compact and other options also.
Perhaps, but at minimum,
Blue Ribbon Commission. I like Blue Ribbon Commissions.
So of course, depending upon what the board's position that's adopted and direction is, that we certainly have all the comments. Appreciate all the thoughtfulness from the members, and we'll communicate that regardless, and see what ideas bubble up.
Great. Any Dr. Tsai?
I think the wording is the most important thing, because anaplastic cancer, life-threatening condition, pancreatic cancer, life-threatening condition, heart disease, high blood pressure, heart-threatening condition, life-threatening condition. So if your blood pressure is well controlled, you're in remission. Right. So if you want to use those verbiage, you have to be careful of what you're talking about. If you're talking about rare and special diseases, that's another category. I know a lot of states have proposed right to try laws for certain medications, off-label use. Those are right to try, but they very much limit the type of conditions. So I think the idea of this bill is excellent, but the verbiage is not there.
And potentially one of the wrinkles in addressing the board's concern is that this is not a new thing. They're expanding out a bit in existing law, which this board also opposed, and doesn't have some of the safeguards that I think the board was concerned about at the time. And that prior bill, it was likened in some of the discussion to a right to try. And you have this sort of this type of condition, and you're, therefore, like, well, why not? What do I have to, from the patient, what do I have to lose, right? One of the things that we pointed out was right to try, other right to try legislation about like cutting edge pharmaceuticals or things that maybe haven't gone through all that, is that it still requires a California licensed physician to oversee that care. So it's a difficult thing. It's a subtle and it's a nuanced thing. I agree with you, doctor, that the wording really matters. But anyway, we'll see what comes.
All right, does anyone want to make a motion? Okay, thank
your microphone, Dr.
Dr. Mahmood moves.
I'll make the motion to oppose.
Moves the staff recommendation. Is there a second?
I think the staff position is opposed if appropriate amendments are not identified. Is that the motion or is it blanket opposed?
Yeah, obviously, I will make adjust my motion to oppose until it is narrowed and appropriately amended, where every concern for the board is cleared.
I second that motion.
Okay,
So-
oppose unless amended. Consistent with this discussion.
I don't know that I have a good sense of what those conditions would be that the board is looking for in terms of to satisfy the concerns. I heard a range of comments, but in terms of we would like this, that, and the other thing, I would hope for some more help from the board on that.
I don't know, it will cover everything, but I would have definitely 3 steps. Number 1, define those critical and life-threatening situation. And how long they would be followed. And number 2, what will be the accountability or what will the board's power to discipline those people if they are involved in any malpractice or any wrongdoing. The board's power is only when we can discipline somebody of doing wrong thing. And we don't have any access to their accountability and we don't have any power to discipline them, then I think we're going to expose Californians or consumers to harm.
Because the purpose of the bill is to, the inevitable outcome of the bill is that the board would not have jurisdiction over, the goal is to avoid having to go through a licensure process. So I'm not sure how to help me out, doctor. I'm trying to think in real time in terms of how this would.
So we have a lot of extraordinary doctors in this state.
Yeah.
And in spite of being the most, the smartest doctors in the world, and they go through this process. And why would we want to expose our people to somebody we don't even know?
Mm-hmm.
I think that's the point in the staff report, which is why we should oppose it, because we have no jurisdiction over these positions if this.
And it's been the historical position of the board, which it feels like there's maybe a shift with how the board is, starting to see this, but we don't have the details yet. We don't know how to quite fix the bill, if you will, in order to.
I'm not sure this particular bill can be fixed. I think we need a comprehensive solution.
It can be
I guess
fixed.
That's what I think the problem is here.
What my fear is that people are going to start marketing it and they'll reach to consumers and say, okay, we have better solution for you. Take the treatment from us. And it will, right now it will say a few conditions, but honestly, in a year, 2 years, there'll be thousands or hundreds of thousands of people looking for that and we won't have any way to stop it. And it will go to not like just few rare conditions. They will come up and they will mend things, and where people will be really in harm's way.
Dr. Yip?
Aaron, if we say oppose, doesn't shut the door for for further conversation, right?
It doesn't have to, no.
So
Yeah.
it seems we still don't have a solid amendment to suggest. We could just oppose and talk to the author. We continue to engage in the conversation, look at more details, right?
We could do that. We could state that, you know, for the various reasons that we've described, that the board is opposed to the current approach. We would like to continue to work with you and see where we can develop, you know, some other approach. But as it is currently in print, that the board is opposed. That's an option for the board.
And that's a reasonable option, yes.
Okay.
Okay, so do we,
Okay.
Yeah,
So
and we can amend to that thing and we can move on there.
okay, we're amending the motion to be an opposed motion from the main
yes,
motion,
with the comments that we want to work together.
incorporating these comments that we want to work together. The seconder supports that. Okay, any further discussion? Dr. Ayala Rodriguez.
Thank you so much. And I agree with that. I just want to like mention the awareness of like probably this bill came out of like lack of access to care and continuous of access to care and incoming worsening access to care. And as there's like lack of some specialties and subspecialties, I think that if we oppose, it's like because we also have that understanding that we really have to bring up a solution within our jurisdiction. I really like, for example, the considering the other options, for example, as the state interstate like compact. And I don't know if like that's something that has been explored like in a limited degree into the, or maybe subspecialties like to a certain degree, not necessarily like everyone, but if we know that there's like access to care issues with the specialties or subspecialties or things like that that are of common public nature concern, I think that we just need to commit to really follow up on it, because I think that we are a stakeholder in this, and the opposed does not solve the public need. And I think that we do have an opportunity to come with solutions, and later on, maybe during the sunset, like we really have to come with a solution or a proposal.
All right, thank you. Let's call the question and do a roll call vote.
Mr. Arkatov?
Yes.
Dr. Ayala Rodriguez?
Yes.
Ms. Chung? Yes. Ms. Holmes?
Yes.
Dr. Mahmood?
Yes.
Mr. Portillo?
Yes.
Dr. Solis?
Yes.
Dr. Tolbert?
Yes.
Ms. Torres? Dr. Sy?
Yes.
Mr. Watkins?
Aye.
Dr. Yip?
Yes.
Ms. Lawson?
Yes. All right, that motion carries. I think that was our last bill. We're done with the bills. Okay, we're now going to do more things out of order. I think we are going to take agenda item 15 next. If Dr. Ayala Rodriguez, you are amenable to that, because I think you are reporting on this item for us. Agenda item 15, please.
And thank you so much, Ms. Lawson. So today I will be presenting the two recommendations from the Special Faculty Permit Review Committee. Following my presentation, I will be making a motion to approve the appointment recommendations from the committee. The first recommendation relates to Dr. Kwong. At its meeting on December 10th, 2025, the committee reviewed and discussed Dr. Kwong's application for a special faculty appointment at Cedars-Sinai Medical Center. And please turn to the agenda item number 15 in your meeting packet for a detailed report on Dr. Kwong's qualifications. Dr. Kwong earned his medical degree in 1995 from the Seoul National University, where he also trained as a general surgeon, and then later he earned both a master's degree and a PhD in medical science. After serving in the military, Dr. Kwong completed advanced training in liver transplantation and liver and pancreas cancer surgery. He's a world-recognized expert in minimally invasive surgery and living donor living transplantation. At Samsung Medical Center in Korea, Dr. Kwong created laparoscopic liver and living donor programs that became models for hospitals around the world. In 2017, Dr. Kwong moved to the United States and worked at the Mayo Clinic and later at the Cleveland Clinic, where he led liver surgery programs, and he helped start the nation's largest laparoscopic living donor liver transplant programs. He has performed more than 1,000 liver transplants, including 700 using living donors and over 1,000 minimally invasive liver surgeries. Dr. Kwon also has published more than 300 research papers and has trained surgeons worldwide. His experience is essentially important in the United States, where there is a strong need for more living donor liver transplant programs to help save more lives. Cedars-Sinai Medical Center recruited Dr. Kwong as a professor and a surgical director of liver transplantation in the Department of Surgery. Pending board approval of a special faculty permit, Dr. Kwong will serve as a full-time faculty member and will lead the development of a living donor liver transplant program while providing academic leadership in education and research related to liver transplantation and hepatobiliary diseases. In this role, Dr. Kwong will bring specialized expertise and training in the surgical care of liver and pancreas transplant patients, including pre- and post-operative management, organ procurement from deceased and living donors, and the treatment of liver, biliary, and pancreatic disorders. The committee recommends that the board approve Dr. Kwong's application for a special faculty permit. Then the second recommendation pertains to Dr. Yahagi. Also at the meeting on December 10th, the committee reviewed and discussed Dr. Yahagi's application for a special faculty permit with the Stanford University School of Medicine. You can also find the information on agenda number 15. Dr. Yahagi is a well-known doctor with extensive experience in patient care and medical research. He earned his medical degree in Japan and completed his training in internal medicine at a major hospital in Tokyo. He became board certified in internal medicine, gastroenterology, and endoscopic procedures, and later he held teaching positions at leading hospitals and universities in Japan. In 2010, he has worked as a professor and research leader at Keio University's Cancer Center, focusing on less invasive cancer treatments. With over 300 peer-reviewed manuscripts, 400 invited lectures, and 25 book chapters, primarily focusing on endoscopy, endoscopic endoluminal minimally invasive surgery for GI tumors, Dr. Yahagi has made groundbreaking contributions to the field. He actually coined the term endoscopic submucosal dissection, and he helped develop the Japan Gastroenterological Endoscopy Society guidelines for gastric and colorectal endoscopic submucosal dissection, which now serves as the global standard for endoscopic cancer treatment. He also holds 34 international patents, showing his strong commitment to improving medical technology. Stanford recruited Dr. Yahagi as a professor in the Department of Medicine and Surgery. Pending board approval of a special faculty permit, Dr. Yahagi will serve as a full-time faculty member with a primary appointment in the Department of Medicine and a secondary appointment in the Department of Surgery. Dr. Yahagi will lead gastrointestinal clinics, perform endoscopic and combined endoscopy laparoscopic procedures, and also will focus his research on developing innovative endoscopic techniques. He will also serve as the director of endoscopic training and education, where he will improve endoscopy training and standardized practices with the goal of improving patient care, efficiency, and the development of new, safer treatment methods. The committee also recommends that the board approve Dr. Yahagi's application for a special faculty permit. And this would conclude my report on the committee's recommendations. Are there any questions?
Thank you. Any questions?
I move to accept both candidates' application. Thank you.
Great. Thanks, Dr. Yip. We have a motion and a second. All right, let's open it up for comments. Any comments from members? Any comments from those in the room? Any comments online?
If anyone has any public comments on agenda item 15, please raise your hand now. Give you a few seconds to queue up. Not seeing any requests at this time.
Okay, we'll bring it back to the board. Seeing no one jumping up for comments, Ms. Struther, if you could please call the roll.
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez,
Yes.
Ms. Chung,
Yes.
Ms. Holmes,
Yes.
Dr. Mahmood,
Yes.
Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres, Dr. Sy,
Yes.
Mr. Watkins, Dr. Yip,
Yes.
Ms. Lawson.
Yes, that motion carries as well. Dr. Ayala Rodriguez, thanks for your work on that committee. We are going to move on to agenda item 16, a presentation on the role of the Department of Consumer Affairs Health Quality Investigation Unit in the board's enforcement process. Ms. Whitley, welcome back for day 2 to you as well. Ms. Whitley.
Good morning, Madam President, Vice Chair Dr. Yip. Hello, board members. It's a pleasure. What? Yeah, am I not? I've never been accused of not talking loud enough. Can you not hear me? Okay, let's try this again. Good morning. My name is Stephanie Whitley. I am the Deputy Chief of the Health Quality Investigation Unit, and I'm excited to be here to give a little presentation on our division and specifically on our Health Quality Investigation Unit. So who we are, we kind of tout ourselves as California's law enforcement branch for consumer protection. Our mission is to provide law enforcement investigative services in order to protect our California consumers in addition to licensees by effectively and efficiently enforcing laws, regulations, and professional standards. So just a quick background. The Division of Investigation was established by legislature in 1961 to provide centralized investigative services for the various boards and bureaus, committees, programs, and commissions under Department of Consumer Affairs. In addition, at that time, the medical board investigators too were also designated as sworn peace officers. With the passing of Senate Bill 304 in 2014, the sworn investigator program that was with the Medical Board of California was then transferred over to the Division of Investigation, which then became the Health Quality Investigation Unit. Just a little quick background on myself. I had the extreme pleasure of being hired as a medical board investigator in 2001, and I did medical board investigations for approximately 5 years before I did actually transfer over to the Division of Investigation, which I have spent the majority of my career working in various roles and positions at the Division of Investigation. I was given the privilege of becoming the Deputy Chief of the Health Quality Investigation Unit. I'm coming up on my 3rd year doing that, so it's been a complete pleasure. So just a quick kind of overview. A lot of people don't understand that our investigators are actually peace officers. So we are under the Penal Code 830.3A of the business of the Penal Code, and we get basically our investigative authority through the Business and Profession Code 160. Our investigators have full peace officer duties throughout the state. We are a POST, which is the Police Officer Standards of Training Oversight body. We are a post participating agency, which comes with a whole bunch of duties and obligations to fulfill those requirements. So just a little overview of who else is within the division, not just the Health Quality Investigation Unit. So we have the Investigation and Enforcement Unit, which we call kind of the old school Division of Investigation. They're comprised of 8 field offices up and down the state. And then you have the Health Quality Investigation Unit. We have 13 offices up and down the state. And we have some of our investigative staff are with us today out of our Glendale office. In addition to our Field offices, we have a unit called the Expert Procurement Unit, otherwise known as EPU, and I'll talk about that unit in just a minute. In addition, we have our Special Operations Unit, or otherwise known as SOU. They are housed up in our headquarters in Sacramento. They are charged with conducting any sort of internal affairs investigations on the department staff. They handle all of our backgrounds for our sworn peace officers and other designated individuals within our department. They handle all of our threat assessment, our workplace violence prevention. So if anybody is making threats against any of our staff, board members, then our Special Operations Unit gets involved and are tasked with handling those situations. They also handle our training unit in addition to our computer forensics. So in our health quality investigation unit, I as a deputy chief report up to the division's chief, which is currently vacant. Kathleen Nichols was our chief and retired at the end of November. So I actually have my co-partner, my deputy chief, Kenneth Garcia, is in the back. He is over our investigation enforcement unit, which includes our special operations unit. We are on a six-week rotation with acting chief. So I am currently done with my reign today, and Ken takes back over Monday. So that's how we're handling the vacancy currently. I oversee area commanders. I have 3 area commanders in our north, our LA metropolitan area, and our southern area. They oversee multiple field offices. And then in each field office, just to give you an idea, we have our supervising investigator. We have 5 to 7 investigators. We have an office technician for support. And then we are also lucky enough to have our medical consultants. So we actually have doctors that work with our investigators on a day-to-day basis working on your cases. So a little highlight on our expert procurement unit. So this unit was established by our previous chief, Kathleen Nichols, in 2020. And it was really designed to help reduce case investigation timeframes by taking those expert at the end, and I'll talk about this again in a little bit, but a big part of our cases, as you all are aware of, is the expert. And so at the end of our investigations, with our quality of care investigations, they go to experts. And so trying to look at efficiencies, one of the areas identified was the expert process. And could somebody that wasn't sworn handle that, right? And so that's why this unit was specifically developed, was kind of to take those roles and responsibilities off of the investigators and, into a non-sworn unit for them to specialize in and to handle that. So we are lucky enough to have a unit with a staff service manager and 5 analysts who work specifically on the expert process. So they prepare the investigative materials for expert, they handle the selection of experts, and then they facilitate the whole process. If there is questions from the expert, they handle all of that interaction to the end of that process. And then basically they package the case up and it is referred back to the board for review. So just highlighting who are our clients. So obviously our main client is the Medical Board of California. We do provide investigative services for the Podiatric Medical Board of California, the Osteopathic Medical Board, and the Physician Assistant Board. And then our IAU side basically handles the rest of the boards and bureaus under the Department of Consumer Affairs. So some of the majority of cases coming to that unit are coming from the Board of Registered Nursing, the Veterinary Medical Board, the Physical Therapy Board, so naturopath, acupuncture, so lots of variety on that side of the house for investigation types. just wanted to highlight some numbers because I think the question came up in the past medical board meeting, kind of the numbers compared to kind of our allied health clients that we are working. So these numbers, especially in fiscal year to date, the 25-26, that basically we're at the halfway mark with these numbers because it's through December, but you'll see that as of December, you can see the majority of obviously our cases are coming from the medical board, 611, with a few from podiatry, OMBC, and our physician assistant. So the majority of our cases we are definitely working are from the Medical Board of California. So we got a lot of questions on training and why, if your investigators are basically have the skills to complete, these types of investigations. So our training unit works very diligently on performing the foundation and the training for our staff. And so just to highlight some of that, but our investigators with just our foundation have to complete a post, either a regular or specialized academy, basic academy, which is 4 to 6 months. When they are hired on, they start into a field training program, and that can last 15 to a minimum to 20 weeks, led by our supervisor and a field training officer, a senior investigator. And then every year, our training unit puts on with subject matter experts from internal, from the Attorney General's office, from the medical board. We put on what we call a mini academy, and that is an intensive multi-week training basically to immerse our investigators in all the specialized knowledge that they'll need to work these types of cases. These cases are extremely complex. I know this is the audience I don't need to tell that to, but these are not easy cases, and we have to be sure to be able to have that foundation for our staff. The training covers a wide range of topics, including, just the minimum of interviewing, obtaining the medical records, subpoena process, working with medical consultants, and experts, handling our cures information, pharmacy records, conducting surveillance, undercover operations, search warrants, report writing, all that good stuff. In addition to our, that mini academy, we're required, just like CMEs for physicians, we are through post. As being a peace officer, we have to have post-required ongoing training. So that is always occurring with our staff. And I think it's important too to note that we are continuing to develop specialized trainings for our staffs and updates when we are developing new information from working with the Attorney General's office, with working with the board on kind of new situations. We are always trying to keep up our training with our staff, keep that current. So some just high-level types of investigations that we handle are, quality of care cases, your negligence and incompetence. Unfortunately, a lot of sexual misconduct cases. Improper prescribing, that could be over-prescribing, under-prescribing, selling prescriptions, and that kind of covers a wide variety. A lot of unlicensed practice of medicine type cases, and sometimes that dips into a licensee being involved, and sometimes it's not. Sometimes we have aiding and abetting unlicensed activity where physicians basically rent out their license to somebody and then they're practicing medicine. So it's kind of a variety of things, or it could just be somebody that's straight up out there advertising that they can diagnose and treat a numerous amount of ailments. So we are tasked with investigating those to protect the consumers. Impairment cases, we talk about 820 cases, another type of investigation that we handle. The 805 health reporting, the mandatory reporting, from facilities, those come and can be extremely complicated. And your dishonesty and fraud, insurance fraud, those type of situations. Some of the kind of Reggie, we were talking about kind of trending investigations, and this isn't take away from our core kind of cases we're working, but just kind of some things that we have been noticing in more recent are the hydration clinics, the illegal compounding that's occurring, that could involve you know, some sort of licensee oversight or none. GLP-1 clinics, again, maybe getting their substances from non-FDA approved sources. We've been having a lot of that, and we work closely with the pharmacy board and other allied health on that situation, because that seems to be a situation that's on the upswing on types of cases. In the news a lot, we have ketamine. We're dealing with a lot of kind of ketamine cases, which is not our norm. I talked about aiding and abetting, and then the mandatory. It is interesting. We are seeing more, and I probably need to get with Charlene because I don't have all the numbers, but it is interesting, and I think it's a good thing. And we're seeing more 805 cases, so I feel like the facilities are being more responsive with the requirement of that law. So we talk about investigative timelines, right? And so, you know, in statute, there is a law, you know, Business and Professions Code 2319 that basically kind of outlines that, you know, cases should on average be worked in 180 days from, you know, the investigation part to completion of investigation. That's an extremely hard timeline to meet all the time, and especially in the past with our caseload and our vacancy rate. But I am happy to say that we are seeing really good progress in that, and that's always our goal. Our time frame for investigation is 6 months. And do we hit it? On average, we're not there, but we're striving really hard. But that is our goal. It also outlines that cases, in complex issue cases, which obviously are the majority of the medical boards, you know, should be no more than the 1 year mark. And how do we try to get that number, right? What are the tools we're using? So our staff, our supervisors do case reviews, and I'm excited with a new collaboration model that started November 1st with the Attorney General's office with Gloria Castro's amazing crew, that they're actually sitting in our case reviews with us. So there's our supervisors, our area commanders, and it's kind of a party session for case reviews. Everybody is there and having discussion on these cases, making sure we are not missing the mark, that we are working cases as efficiently as we can. So we have all the parties kind of in that room. So those occur every 90 days for cases on the regular, and those are for every case, but on cases that are over a year, the requirement of staff is that they're doing case reviews every month. And all this information is being input into Breeze also. So that information is shared with board staff. For cases over 2 years, that's every 2 weeks. So we try to keep a really tight handle on those cases to make sure that all eyes are on them and they're not aging for reasons that they shouldn't be. I get to meet with your board staff once a week and have very fruitful discussions, not just on current, you know, case questions, but other topics. So that's another way that we're held accountable and have discussion after reports are sent to board staff. And those automated reports, those are really good for. As I just discussed, that they start conversations for board staff to understand kind of where we are with some of the cases. I worked on this chart. This might be a little rough, you guys, but so with certain exemptions, the medical board's complaints basically are if they're determined to be involve quality of care, they must be by BMP 2220.08. They're basically they have to follow a set of steps, and that set of steps includes being reviewed by a consultant in the same specialty before they actually come out to us. So if you look, hey, look at Sean, I got the pointer. Okay, so when those complaints that come in that are of quality of care nature, then they do come to the board. They go to a MC for an MC review. That case is either then handled to finish by board staff, or then it does come to us. And then we work the case, and the case then will be returned back to the medical board, or, and if applicable, then we'll refer the case either to the DA or AUSA if that's deemed appropriate. Now, there are certain exceptions to that law for urgent cases, and that involves complaints that have immediate danger, or there's already a case on the subject out in the field, or if that subject is on probation, then those cases basically follow the below path of they get referred out immediately to us and then back to the board or DA if applicable. So in statute, we basically have our case priorities listed, and that's in BMP 2220.05. And so that basically gives us our roadmap of what cases we shall work in priority. In kind of common sense, right? Those are cases that involve death or serious bodily injury to one or more patients, such that the physician or podiatrist represents a danger to the public. Drug and alcohol abuse involving death or serious bodily injury, repeated acts of excessive prescribing of controlled substances, sexual misconduct with one or more patients during treatment exam, practicing while under the influence of alcohol or drugs, and then repeated acts of excessive prescribing of the psychotropic meds to minors without a good faith exam and medical reason. Some of the other cases that we look at that are high priority to us that are not necessarily listed in statute, though, are, we do have a statute of limitations. And so we are kind of always trying to be ahead of the curve on that. And depending on when this board is notified about the complaints, it could be, we could have very little time. So identifying cases that the statute is expiring in 6 months is extremely important, because we want to get, no matter when we get a case, we want to do as much as we can on that case to ensure consumer protection is fulfilled if deemed appropriate. Keep a super close eye on our 2-year-old cases. Those are a high priority to staff. If you ask them, their commanders are on them on the 2-year-old cases, because we understand that we are part of this puzzle. We have a handoff method here, and we need to give our clients the time to review, determine if they're going to forward to the Attorney General's office. And so the more time, the better for everybody. And so we are very cognizant of that. So we keep a really close eye on our 2-year-old cases. Any impairment cases that are not necessarily, deemed as causing serious bodily injury or death, we obviously keep an eye on those, because the potential for harm to the consumers is extremely high. And then obviously cases that of subjects who are already on probation. We know the road is hard to get down this whole process to get our licensees on probation when deemed appropriate, but we understand that when we get another case on a probationer, that it's extremely important that we do our due diligence to work on those as soon as possible to ensure the protection of the consumers. And then the unlicensed practice of medicine. I can't tell you how many cases I had of people injecting construction grade silicone into people's bodies. I mean, there's some serious harm that is going on that our consumers unfortunately unknowingly go into uneducated with information. And so we take those extremely serious because we need to get those people off the streets. And so those are some of the other cases that really rise to our priorities. These are just some really kind of rough general investigative steps that our investigators go through. Obviously, when we get the complaint, we review that complaint, we interview the complainant. I think as an investigator, I have been around this work for 25 years, and I could tell you my first case I worked, and why I've stuck here this long is because of my relationship I built with my complainant, with my consumer, building the trust in them, and having them provide information to me that is very personal, that they knew could become public if this case went forward for the sake of the consumer. And so building that rapport with our complainants is very, very important. So that's the first step that our staff really take, is to develop that rapport with our complainants to be able to get all the needed information to move forward. Then we interview all other relevant witnesses. We obtain the relevant records, documents, any other evidence deemed necessary. We can conduct surveillance, do undercover operations. We work closely, and again, we are so blessed to have medical professionals within our field offices, and so our staff get to work with them really closely to review these type of cases. So medical consultant review is a big step in our investigations. We're writing subpoenas and search warrants. We obviously will do a subject interview, and as noted before, that expert review, it's finding the appropriate expert to review a case to be able to render an opinion on what has occurred. And then, you know, depending on the type of case, if it has criminal elements in it, those cases will go to the DA at the same time the case will come back to the medical board. Did want to highlight that our staff don't make recommendations on cases. That's not our role. That's for our clients to determine. And so you'll note in our reports, we're neutral fact finders. And so we're gathering information to either prove or disprove the allegation. It's what we do. It's what we're charged with. And then the decision making is left with those at the board or at the Attorney General's office. You know, just looking at those timeframes, right? What can cause us delays and impact our timelines? If we have uncooperative facilities, going back and forth, and I can probably pull 2 investigators out of here right now and have them sit down, that can be extremely frustrating. Some facilities just do not want to be extremely cooperative with us. And so sometimes it takes them a little bit of strong arming and could involve the Attorney General's office. But, you know, we get down the road, it just could be more, it could just be quicker. So that sometimes affects our ability. You know, sometimes we have cases involving 20 patients, and you can imagine that causes delays with the amount of medical records, the amount of witnesses. So that is a big one. Kind of delay in or refusing to produce records. We obviously, by law, have a mechanism to get them, and that's through the subpoena process. And we use it, and if they don't comply with that, we go through with medical board staff, we go through the enforcement, we forward it on for the enforcement of that subpoena, but it's just lengthy, right? And again, just adding more time. We'll get there, it's just adding more time. A lot of times we have witnesses that disappear on us or don't want to cooperate. And again, subpoena enforcement or just some of those complex criminal investigations that could take, you know, search warrants or undercovers. Those also can cause us some delays in meeting our goals. But I did want to highlight that that we are making strides in bringing that case aging down. Excuse me. So just from you know, January to January, we're seeing a great downward trend in those cases. In addition, I get to review all the cases that go to the expert procurement unit, go to our manager. I get to review those cases, and it's a lot of cases. And so what I'm seeing some cases that we're getting done in 6 months. You know, the investigation is. So I am extremely hopeful that our timelines are going to keep coming down because of what I'm seeing just with the cases coming through now for completion. Who are our enforcement partners? Our greatest enforcement partner is the Health Quality Enforcement Section of the Attorney General's office, led by Gloria Castro. And I can't thank her enough. With her team, with this new collaboration that has started, we are seeing I know you might not see it in the numbers, obviously, right away, and we know that, but what the feedback I'm getting from staff is extremely positive, and the advice and the direction that they're providing is so appreciated. So I just can't thank her and her team enough for that partnership, but it's going extremely well. Some other partners are, we work with Medi-Cal fraud and elder abuse statewide because there's a lot of crossover in complaint types. Some of our local federal, obviously our local district attorneys who are take the majority of our criminal cases. We work really closely with them. California Department of Health, DEA, California Department of Insurance, we work with the FBI from time to time, and then our FDA partners too, a lot of times with those substances being shipped in that are not FDA approved. We get a lot of help from them. And I think our other big partners, and this is kind of what we have seen when the medical board investigators came to us, was that kind of the partnerships with the rest of the boards and bureaus. You guys can imagine, and I hear stories, the care that is provided or that we get complaints on doesn't just always include the physician. It includes nurses, you know, respiratory care therapists, you know, and so the working together with the other boards to be efficient is extremely helpful to our staff and to our investigations, which, you know, comes back to our clients. And then and some too, especially on our insurance fraud cases, we're getting a lot of information from those insurance companies. Their special investigation units are skilled at looking all kind of at the billing end of the records. So, you know, continuous improvement strategies for staff. We have a unit that we are in our training section that we're constantly updating our policies and procedures and our best practices. We provide that ongoing training to our staff. Part of our collaborative model that we started is developing trainings with the Attorney General's office that they're seeing trends on to be able to in live time conduct those trainings. But we had the 805 training of recent, which was the mandatory reporting from facilities that we partnered up with the Attorney General's office. That's the type of stuff that we want to do. We need to stay current on issues and to continually train our staff to make sure that they have all the most updated information and tools to work their cases. You know, our staff are, we're kind of out there, so we're monitoring any sort of trends in healthcare. We kind of talked about those already. In technology and all the AI, boy, we've had lots of AI conversations. So I'm very interested in all of that, because that's not only affecting the practice, how we do our investigations, but us as law enforcement officers too, how we're dealing with AI. And I think our biggest one is we continue to maintain and develop those relationships with our stakeholders, right? And it's understanding each other's perspectives. And that's why I appreciate this board staff so much, is our relationships that we have, and just trying to build efficiencies and doing this job better for all of our mission of consumer protection, because we all take that extremely seriously. So just part of our strategic goals that we had set up, prior to 2022, again, is it's always focused on the quality of thoroughness and the timeliness of our investigations, so we could get those back to the boards and bureaus for appropriate action. To strengthen our communication with our boards and bureaus, right, to be able to provide updates and transparencies on what we're doing and how we're handling their cases. And then the standardized training for all of the division staff, to ensure that everybody is doing everything in best practices, and that we're all doing the same thing in our roles. Okay, I think I got through it.
Thank you, Ms. Whitley, for that presentation. I think that was, not only was it comprehensive, it was extremely informative about, and frankly, in the more than a decade I've been on the board, that was a very helpful overview of how this all works. So thank you. I really appreciate it. Any comments or questions? Okay, we will start with Dr. Yip, and then we'll go to Dr. Mahmood, and then we'll take others.
Sorry, I have to strain my neck for that stuff. Thank you so much for the review, particularly we have so many new board members now. One question maybe Reggie can also help answer. Years ago, I remember medical board has something to do with the accreditation of surgery center. But we don't do any survey and we don't do any oversight. We still have a role in the surgery center.
The medical board approves the accrediting agencies that accredit surgery centers. And of course, there's other pathways as well, including being licensed from CDPH or CMS certified, among others.
So for your unit, you do have authority to investigate a case related to surgery center, but not do the survey.
Right.
Okay. And the second question is that I think Reggie or our medical board participate in the annual medical staff director training or meeting. It may be a good idea that one of the staff go to those meetings and encourage the medical staff director how to work with their leadership in the hospital as far as the reporting 805. I do feel those are under-reporting.
Mm-hmm.
Thank you.
Great suggestion, Dr. Yip.
Thanks, Dr. Yip. Dr. Mahmood?
Yeah. Thank you so much. Such a comprehensive report. And one good thing, the shining part is that wait period over a year has gone consistently down from 2020 to 2026, almost half. Have you looked into the factors? What has helped you on that? How can we consolidate on that? Because that is really one very important issue, because people need solution for things and we are in the right direction. And what else can be done to shorten it further?
Time frame.
And we look at the 6 months period too. How is that doing?
Right. So I think, and this is my other update, but our vacancies, just the reason the reason timeframes have come down, number one, of our caseloads have come down to an actual manageable caseloads, and that's because of our vacancy rate. We are experiencing, and I haven't checked, I should use AI because obviously it has this capability for the vacancies, but we're at probably the lowest vacancy rate we have been for I don't know how many number of years. And so that We are to have adequate staff to do these investigations is really kind of was the crust of, I think, the problem with our case age. And so now that we have kind of, right, that big portion, we are coming down. We currently have 12 investigator vacancies, which is down from 26 last year at this time. So with that, then we're trying to basically get those staff trained up, so obviously in any profession, when they start, they're not going to be at their full potential. So as we see those new staff come on, get the training that they need, and basically be able to work at their top capacity, I see us being able to keep taking those large chunks of time out of our investigative timelines where we can on average, right? There's just some instances that we just can't help. But on where we can control, I think we'll keep seeing those. So I think with the vacancy rate, that has really helped us. We have some good tools now, especially I think working with the Attorney General's office, that they have a unique perspective, right? We're the investigator, they're the prosecutor, so they're looking at different things sometimes than we are. And so with them involved with cases in the upfront, they really kind of can pinpoint things that we need to focus on sometimes. And so that will help us cut down unnecessary areas that we're maybe working that they don't think is a top priority. So I think with that, our training and our new staff, those are all trends to keep those times coming down. But a large majority is getting those caseloads down so our staff, they're manageable and they can be worked.
Turn your mic on, please.
Oh, sorry.
So just the main reason is that the vacancies are filled and you have enough staff. I think there are like 5 other factors you mentioned. I don't know. Do you have any control on any of them? You mentioned 6 reasons why the cases are delayed.
Oh.
And one of them was probably not enough staff. All other 5, do you have any control on the rest of the 5?
So,
don't see much.
So this board got the tool of the subpoena enforcement process, which basically will toll that time when the enforcement. I'm losing what the action is exactly filed, but those type of tools are really good for us. Unfortunately, and we have the new law that basically requires a physician to participate basically in the interviewing process. And so in making that unprofessional conduct. And so there are good tools. Those just take time. So where we are trying to identify the things that we can control in our investigative world, but there are other tools. Unfortunately, it's just their laws and the laws that their processes. So, so to answer your question, Dr. Mahmood, because I don't think I'm answering it great, but there are, we're dealing with people. And so when you talk about trying to cajole witnesses or find witnesses, some of that stuff is just out of our control. It's just part of the nature of the investigative process. But where we can identify efficiencies, we are. It's like if our investigator can't get a hold of a witness, we go out to the witness's home, right? We don't send letters and letters and letters and say, oh, it's been 3 months, we can't find the witness. Our staff are able to get out and go and try to make that contact as soon as possible. So it's whatever we can do in our abilities is to be able to knock that time off is we do.
Yeah, and I agree with you. I just wanted to ask this loud, but there are certain things you can control and there are many things. Most of the things are not in your control. So that delay is going on.
Yeah.
And if there is anything board or anybody can do to help you to make any difference in those issues where you don't have much control.
I'll ask staff and they'll probably come up with some.
Thank you.
Thank you.
Okay, I see a lot of other interested folks. Dr. Tolbert and then Mr. Watkins.
Well, thanks to Dr. Mahmood. I have fewer things to ask. So I just wanted to acknowledge that, well, thank you for that presentation, first of all, and just acknowledge that some of your delays, so to speak, are really speak to the complexity of your job and what you do. So I don't really necessarily see that as a delay, but really a reality of how hard your guys' job is. So I appreciate everything that you do to help protect the public. And the other thing is I think was not mentioned. The trending investigations, I found those to be really interesting. And, you know, at some point it might be good for the board to take a look at those in terms of like our own education around some of these trends. So that's one thing I'd like us to consider.
Sorry, Mr. Watkins.
Thank you so much for this presentation. You know, when you see the whole thing in its entirety, a lot of the things start fitting in for me personally. And I just want to say thank you to you and your team for continuing where your previous director has passed on the baton. You are doing a great job. I mean, it instills some trust in me that you are really investigating these cases. My question is, the clear and convincing is the standard. And also, I'm really love this relationship with the AG's office and your office, because the clear and convincing standard, when you start this investigation, that's the goal, I would assume. Is that the goal? To meet that standard? Or is it just we do the investigation and then we check whether we are at the threshold or above? I just want to get that in my head clear.
It's a great question because it actually comes up a lot, especially in training. We don't train our investigators to stop at any threshold, right?
Okay.
We train our investigators to get all applicable evidence and information on every complaint. You know, whether it has met that burden of proof or not, we don't take that in consideration, and we leave that up to the prosecutors on the case. But we teach our investigators, you get, if it's applicable, you get it. Does that answer your question, Mr. Watkins?
Yeah,
Okay.
because, you know, it also follow-ups with my previous concerns, which is, you know, now that you're communicating with the AG's office, because by the time we see a case, I mean, all the board members that sits on a panel, I mean, it literally looks sometimes like that whole case disintegrates in front of us. And then we have to make decisions based on whatever that is. And then you would know the facts of the case and you see them. So you have a pretty good understanding. The agent knows the facts of the case and they give an interpretation of that case to us that we didn't have to make a decision on, placing a lot of reliance on what the Attorney General office is recommending. My question is, in this scenario, this new collaboration, does that inform you how to better, you said it to a certain degree, I just want to confirm that, your process, like on focus areas, so we are really zoning on what the important things are that is required by the AG's office in order to proceed with the case successfully, if you will.
You know, having the Attorney General's office, having DAGs or SDAGs with us gives us a unique ability for them to provide their perspective on cases and to, yes, like you said, Mr. Watkins, to be able to maybe point us in some areas that we need to dig a little deeper. And then on some areas that we are good. And like you all have said, these are very complicated cases, and what we think, and when I back up and I say we tell our staff to get everything, you know, I say that they're humans, they make mistakes, and we can miss the boat sometimes on that type of stuff. But I think having the AG with us during these processes gives us a unique ability to hear their feedback live on what they are identifying as a need to have to further take that case. So yes, to answer your question, I think the what we're getting, the benefit out of it is I think great.
Well, thank you so much. I'm looking forward to seeing how that actually plays out in the reality with the numbers on the board. Thank you.
Thanks. Other comments or questions before we take public? Sorry, Mr. Portillo and then Dr. Sai.
Yeah, you mentioned you have about 12 vacancies right now in your investigators. How many total positions do you have?
We have approximately 81 investigator positions that are actually in the field. We have other investigators in other roles, like in our training unit and such.
I saw you had a goal to kind of try to get it done within 180 days. Is there a sense that if you were fully staffed, that that's enough positions to be able to meet that goal? Or do you think you may need to have additional resources on top of your current?
No, I think if we could get all of our vacancies filled and get everybody up to speed and on trained up and into their full capacity, I think it's a doable number.
Okay.
Yeah, on average, I do.
Was there anything that struggled to fill those positions, or do you have an easy time filling the positions?
How much time do you have?
Well, I guess what would you say is the biggest?
I think, there's been many kind of like why are our investigators leaving? Why do we have vacancies? We had lots in the past that were going over to become special agents for the Department of Justice who make significantly more money than our staff does. And that's a battle that this board has always supported. And it's just a battle that's going to continue to be battling. So unfortunately, I did receive notice that we are leaving. I do have a staff leaving to go over to the Department of Justice for more pay, but I think we also used to have the higher above minimum. So process through the state, which basically, if you had a detective from LAPD, and we have a handful, and we're grateful for them and all of their experience that they bring on, we could basically look at our pay, and you could bring him in at the high step, right, of our investigator. That ability was taken away from us through for our classification. So now we aren't able to do that. And so that's been difficult for recruitment purposes, is when you're trying to bring somebody on, or even if they're retiring, if they're trying to lateral and they're going to take like a $2,000 a month pay dip, we have lost a handful of people because of that. But in despite of that, we are out there. We're going to recruitment fairs. Despite those setbacks, we are making really good headway on getting people hired and on board. So I'm hopeful that the things we have in our capability, that we can get there.
Okay. And is the department I know at one point they were using non-sworn peace officers for more like administratives, getting copies of records, things like that. Is that still happening, or?
So in the investigation and enforcement unit, they do have a handful of non-sworn special investigators. We did have 3, we're down to 1. We found that because the medical board does have their own special investigative unit, those special investigators for this side of the house really didn't work as what we had thought that they could help provide. What we really have established was that the expert procurement unit has kind of helped with some of those duties that the sworn investigators don't necessarily need to do, that they could support with. But we're still always looking for ways for other staff to support in the efforts of the sworn, and not just have that on the sworn investigators.
Okay. And on the cases that some listed were 2 years or older, do those cases still need to go through the AG's office, through their process on top of that? Or is that kind of encompassing all of that?
No, so those cases that I've identified as like as 2-year-old, those are still with us. So those need to still then go back to the medical board and then for review, and then if they deem appropriate to the Attorney General's office.
I thought I heard yesterday somebody said that the deadline for action is either 7 years from the time of the incident or 3 years from the date the board becomes aware of it.
Right.
So in cases where a investigation goes to that 2-year mark, how likely is it that the board could take action, even if it wanted to, just because the amount of time it's going to take us, the amount of time it's going to take the AG?
So your statute of limitations basically hits when a formal accusation is filed. Correct, Carrie?
The accusation has to be filed within that 3 years. Yeah.
So I guess are we losing a lot of cases that we're just not pursuing because we hit that how many cases are we hitting that statute of limitations on? Because we didn't get through the process in time.
I think the question is how many do we miss filing because we blow that deadline because the investigation takes too long or what have you?
That's probably a number we need to research and get back with you on.
Okay.
That's why there's a push. And so we could get cases because of the 7-year, 3-year that have 6 months on them. So it depends on the 2-year one. The 2-year-old cases, though, that I have identified are those cases that have been with us for 2 years that have that there has been some sort of delay outside of our control a lot of those times. But that's why we keep that close eye on, because of the time that's basically needed to get back to the board and then over to the AG for review.
Yeah. No, I definitely want to make sure you guys are not being put in a situation where you're gonna fail no matter what, because you don't have the resources necessary to do that. So, but I think it would be helpful to kind of get a sense as to how many just weren't filed because the clock ran out. Or actually, even this consensus, like, hey, you found that 80% of all the cases that you investigate, you're able to complete within that 80%, that 180-day time frame. I think that's a great statistic, and I think that may be something helpful for us to kind of say what's the goal of what success looks like. So if we say our goal is for you to process on average, by 365 days or 80% of cases within that 180 days, I think that would be helpful to kind of see if we're making that type of progress, to see what success is. But something like that, I think, may be good as you're looking to, what your goals are as a strategic planning effort.
And I know I talked too long, but just a really quick follow-up that we really we've had recent discussions with Reggie and Marina and Charlene that talking about developing some more kind of reports, because sometimes it's difficult in our Breeze environment to be able to give us reports, to give us data to look at, to be able to identify some of the things that you had just discussed. And we have talked about further developing some reports to be able to outline some of that information. Yeah.
I think we had Dr. Sai.
I'm just excellent presentation again. On your bar graph that says MBC investigations over 1 year, the number represents the number of active pending investigations, right? So over the last 4 years, it's coming down, and there's still 250 cases that's still pending. And if the numbers are correct from your previous slide, about 1,000 cases are referred. So over the last 4 years, we have roughly about 3,800 cases. So more than 90% of those cases have been finished. So I think that's an excellent statistic. So if you look at the numbers, obviously there's still 250 cases pending, but I think this efficiency rate is excellent. So thank you.
All right, other comments or questions before we take comments from the public? Yeah, go ahead.
Thank you for the presentation. I had a question about the slide, the HQIU expert procurement one. And just to clarify, you're talking about the medical experts, so preparing the materials and sending it to the medical experts. Can you clarify for any physicians who may be listening, because I know yesterday we had an update about how we need some more medical experts in certain specialties, but what's the minimum requirements to serve as a medical expert and the training involved?
I'm not an expert on the expert, so I'll probably defer that question to staff, board staff, to be able to answer.
Do we have a staff member that can answer Dr. Solis's question?
The requirements for expert.
The requirements for experts?
I want to be careful doing it on the fly, but certainly, board certification, they have to be in practice for a certain period of time. No disciplinary history, no pending complaints. But it may be worthwhile to do a more detailed presentation that lays it out specifically.
Yeah, I think that would be helpful just because yesterday we heard about some outreach efforts from our staff and how we still need some more experts in certain specialties. So I saw it outlined, some of the training requirements for the DOI investigators. So I just thought that would be helpful, but appreciate that. Thank you.
So, the expert unit of the medical board handles the vetting and the approving. But we do, anytime our expert procurement unit works really hand in hand in case we need to find additional, maybe off list experts. So they do work closely with the expert unit. But your expert unit within the board is very proficient on and has all that information also. So
thank you.
All right. Reggie,
Want to be sensitive on time, so I just want to make sure everyone's aware of that.
I just want to add on to just FYI, on our website, Dr. Solis, if you can search for expert reviewer program, there's a page dedicated just for that. And it's titled Join the Medical Board of California as an expert reviewer. And there are minimum requirements listed there. Qualities, there's a lot of resources, including expert reviewer guidelines, model expert sample options. So I would just say that, put it out there that that's an excellent source to start with. Yeah.
Thanks, Rich. Okay. Additional comments or? All right, let's take comments from the public. Anyone in the room that would like to comment?
Good afternoon, board members. My name is Marcus Friedman, Administrative Director for the Consumer Protection Policy Center, or CPPC, at the University of San Diego School of Law. We have monitored state agencies for over 40 years and have quite the expertise when it comes to matters such as this. As we heard in the testimony today, there is a great help when deputy AGs are working alongside the investigators into this program. And it speeds up the investigation because it provides guidance with the investigators as to what exactly they're looking for and able to meet that standard to go forward once a case is handed off to the AG's office. A couple years ago, about 2 years to the day, there was an enforcement monitor that talked about vertical enforcement and the need for the deputy AGs to work hand in hand with the investigators to speed up this process. I want this board to kind of be aware and understand that this is something that can be changed, not just through collaboration, which CPPC is glad to see with the HQIU, and future testimony we'll hear from the AG's office briefly in a moment. But it's a good idea to know not just to collaborate, but especially as you're going into sunset review, what parts of the legislative code can be changed to encourage early implementation of deputy AGs in the investigation process to ensure that this is being speedy and the investigators have that guidance and being able to make that standard once it does get handed off. Thank you.
Thank you. Additional commenters in the room? Sean, can you open it up online?
Yes, if you'd like to make a public comment here on agenda item number 16, please do so by raising your hand. First request here we had here was from Monty Goddard. Monty should be receiving that prompt.
Good morning. Hey, before I make my comment, it's very brief. I got to compliment you guys on the improvement in your audio and in your video for these meetings. It's really quite remarkable. My name is Monty Goddard. I'm a 46-year California licensed civil engineer, and out of necessity, a patient advocate. I appreciate the very informative HQIU presentation. I did not hear or see any mention of medical board policy or guidance training. Subsequent to the publishing of the board's July 23 prescribing guidelines, in public comment, I asked an HQIU presenter at a medical board meeting if HQIU investigators were trained on the guidelines, since they are a significant shift from the medical board's infamous death certificate project approach. Referring to the updated guidelines, the response was, we gave them a copy. In my opinion, that action is woefully insufficient to counter the systemic culture created by the death certificate project. I hope some meaningful training on the board's much improved prescribing guidelines has subsequently occurred. Thank you.
Thank you for your public comment. Next, here we have Marion Hollingsworth. Should be receiving that prompt.
Okay, can you hear me?
We can. Please go ahead.
Hello, this is Marion Hollingsworth, patient safety advocate. In listening to this assessment by the board's investigative unit, I was shocked to learn that it takes you 2 years to make a case a priority. I know you have a 3-year time limit to file an accusation. However, it seems extremely negligent to let a case just languish in a file for 2 years before it's made a priority, kind of a, oh yeah, we should get on this. This means like during 2 years, dangerous doctors are allowed to practice unfettered. A good example of this is Dr. Carlos Chacon, who is now an inmate, who ultimately was charged with second-degree murder after the death of a cosmetic surgery patient. You remember, he allowed an untrained RN to give sedation to his patient, and when that patient coded, he saw other patients for 3 hours while she was literally dying in his OR. So you're saying a case like this took 2 years before you made it a priority? Is this why it took you 3 years to file an accusation right before the deadline against Chacon? He was performing unsafe surgeries during this time and you knew it, but it wasn't a priority for 2 years? I mean, it's just mind-boggling that harm cases, especially ones that involve deaths, are not handled more effectively and given a priority status immediately. I know you can do speedy investigations when you want to. You recently put an addicted anesthesiologist on probation in less than a year after she collapsed in an OR. So it is possible for you to act quickly when you want to. I ask you to investigate the numbers of cases that you have left over the past 5 years in files before you finally made them a priority. You can report back in the next meeting about why these cases were 2 years old before they were made a priority. I just think it's inexcusable to wait 2 years before deeming any case a priority. You should do better to protect the public. Thank you.
Thank you for your public comment. Next, here we have Rob Gordon. Robbie should be receiving that prompt.
Yeah, can you hear me? A bunch of windows just popped up.
Go ahead, Rob. Yep.
Yeah, I'm kind of reluctant to join the crowd on this, but that was a good presentation. I'm always behind, but the Abolish MBC website is up and running. With I mentioned we have an AI model video section, so I'm gonna if you could hurry up and get this video published, we'll do that. And you know this meeting or this session or whatever did have some kind of entertaining moments. I love that one where the poor clueless doctor, oh, my privacy, don't mind me. That was just, the guy was so weak and so pathetic. I just can't wait to get that one. And of course, also the psychiatrist who, watch out for that Rob Gordon. He's planning to retaliate. So I've already, I need his name and his company name. I've already requested that. And I have to say, of course, Marion Hollingsworth is absolutely correct. The timer stuff is just absurd.
Mr. Gordon, can you focus your comments on that?
No, I cannot. And you need to focus and stop interrupting me, because this has happened several.
Thanks. All right, let's move on to the next commenter.
At this time, there are no additional requests in queue.
Okay, we'll bring it back to the board for any additional comments. All right, seeing none, Ms. Whitley, thank you for your presentation. We appreciate it. We're going to move on next to agenda item 17. which is a presentation on the role of the Attorney General's Office Health Quality Enforcement Unit in the board's enforcement process. We are going to learn more about how this works. This is the next step. Welcome, Gloria.
Good morning. Still morning? Yes. So thank you so much for the opportunity to come and present today. I've been a lawyer for almost 30 years, and I've had the privilege of working at the Attorney General's office for 25 years. And I joined HQE in 2005 after spending 6 years in the Civil Rights Enforcement section in the Attorney General's office. I moved up quickly through the ranks in the Health Quality Enforcement section, and I was appointed Senior Assistant Attorney General by Kamala Harris in 2013. And it's truly been the honor of my life to be able to lead such a fantastic group of people at the Attorney General's office, to work with folks like Stephanie Whitley and her team, and obviously to serve you as your lawyer in these prosecutions to protect the public. The learning objectives today are to provide an overview, especially for our newer board members, who I welcome. I want to present to you HQE's role and statutory obligations, details about how we are involved in your enforcement matters, and a brief explanation of the various considerations that impact your timelines and outcomes. And we will also cover a few features of the role of the Office of Administrative Hearings and the rights afforded to accused licensees in your accusations. I was about to say next slide, but I just realized it's me. All right. Here's the Attorney General's mission statement. And as noted, public protection is clearly our mission. And this also includes the fair and impartial enforcement of laws to ensure justice, safety, and liberty for all. The underline on the all means everybody involved in your cases, doctors, patients, etc. HQE has 71 authorized positions. It's comprised of 1 senior assistant, that's myself, 9 supervising deputy attorneys general. I'm pleased to be joined today by 2 of them, Edward Kim and Judith Alvarado, who are 2 of 3 supervising deputy attorney generals in the Los Angeles office. We have 50 deputy attorney generals, 9 senior legal analysts, and 2 associate governmental program analysts for the entire state of California. We're exclusively dedicated to health and quality enforcement and nothing else. We are privileged to serve not only this client in our portfolio, but we also represent the licensed midwives, which is part of your program, Osteopathic Medical Board, Physician Assistant Board, Podiatric Medical Board, and 7 other Department of Consumer Affairs health clients. We're highly specialized in the norms of healthcare delivery in the state of California. The HQE team is highly specialized in civil defense work as well, both defensive and in any forum, state, federal. At times we have to dip into bankruptcy court and other odd places that our work takes us, but we're prepared for any challenge that you put in front of us to help defend you and your program and your mission. Our team has a high level of experience and longevity in our section, which we believe is reflective of their passion and commitment to the work that we do for Californians. The health quality enforcement section is codified in various laws that explain our role, and we're lucky to have many subject matter experts on our team. And we are a relatively small group of smart, passionate, and diverse legal professionals, and we love our work, just like you and Ms. Whitney's staff. I report to Chief Assistant Attorney General Monica Anderson, and she reports directly to Rob Bonta, our Attorney General, who is awesome. The licensing section is our sister section in the Attorney General's office, and they too represent DCA clients. Their mission's a little mixed, but they also have healthcare clients in their portfolio, such as pharmacists, dentists, and nurses, which we do not have in HQE. This statute was codified in 1990 when we were created following legislative action at a medical board sunset review hearing. In the last 4 decades, the Health Quality Enforcement Section has been involved in different roles in the medical board's licensing, probation, investigation, and administrative prosecution. We also represent, like I already said, other parts of your program, and that includes midwifery, polysomnographic technicians, probation unit, licensing, you name it, we do it. We have given several budget presentations in past board meetings, but briefly, you, the medical board, sets our budget from which we bill for all of our work. That is called the Legal Services Revolving Fund. DOJ generally, not just HQE, uses a case management system and timekeeping system called ProLaw. When work is received by us, a matter is open in ProLaw with the medical board's billing code, and transactions, time entries are logged into each case, and they're accompanied by narratives and task codes that are very descriptive. We can bill as little as 0.25. The DOJ's accounting office sends the board an invoice and a billing detail report every month that includes every single transaction detail for all cases billed in that month. HQE also vigorously presents any data about aging, pending caseload, where we are at. We know exactly where every single case is in our system and who it's assigned to and how long it's taking. It's a constant. Your board materials also show you how our LSRF, the Legal Services Revolving Fund budget, is used every quarter. Your staff diligently puts together so much information for you in your board packets. So for example, in this quarter, if you refer to 6D, pages 9 through 10, pages 12 through 13, and 14 through 16, you have every single piece of information that you need to know about where we are right now with your work. So the Health Quality Enforcement Section assists the board to carry out its mandated disciplinary functions as you request. We assist in trainings and presentations as needed. For example, Ms. Whitley just spoke about the mini training academy. We send representatives there. SDAG Edward Kim recently presented at the Opioid Summit, which Mr. Rakis is going to potentially speak about today. And Gregory Chambers, our SDAG from San Francisco, presented in those 2 big presentations and collaborations with investigators on Business and Professions Code Section 805 to really put teeth in that program and encourage reporting by peer review committees, such as the ones that are at hospitals like this. We have liaisons in every unit of the board, such as licensing, probation, and the complaint investigation office. This includes Supervising Deputy Attorney General Judith Alvarado, who goes up frequently and helps support various programs. And of course, the licensing chief as well. With the recent reinvigoration of the collaborative model, which is much smaller than the vertical enforcement, but it's a good start. So thank you very much for reinvigorating that. We have DAGs embedded in HQIU investigation centers statewide to further your goals and your mission. We will discuss that a little bit later concerning filing burdens and other factors that influence enforcement outcomes, such as case complexity, evidentiary strength, expert testimony, and statutory mandates, such as the statute of limitations. We currently have about 60 collaborative model cases since November 1st, 2025. So it is a drop in the bucket from the overall investigative caseload. However, as Ms. Whitley has already pointed out, there are a lot of soft applications of our legal skills to the investigators, both in training, onboarding, and providing more focused information on where to go potentially. We really enjoy working with our investigators, and we've been really excited to rely on really talented Deputy Attorney General fives. These are people that have more than 20 years of legal experience. They have enjoyed wearing the white hat. They have those soft skills to be able to meet with investigators, teach, mentor, coach. And we're also excited that Ms. Whitley really has engaged with us to be able to allow investigators to come to our Office of Administrative Hearings casework, at least to have investigators see the fruits of their labor, which I think is really important for commitment and morale and team building. So thank you, Stephanie. We're also privileged to work very closely with Carrie Webb, your in-house counsel. You're awesome, Carrie. And we appreciate everybody's experience and passion for their work. This is just a selection from this statute that is of relevance today. When the legislature envisioned the roles of the executive director and the staff of the medical board, the prosecutor, HQE, and the neutral trier of fact of law, which is Office of Administrative Hearings, it figures into how this system is set up. So in this manner, the checks and balances exist between the prosecutor, which is housed in the Department of Justice, and hearing judges, which are housed in the Department of General Services, but purely for administrative purposes. They are entirely independent from DGS, but they represent a lot more clients than the medical board in managing that work. They're important because they're the ultimate decision maker right before you. So they analyze the materiality, admissibility, relevance, weight of every piece of evidence put in front of them. And then they bring it to you as proposed decisions. They deal with every single piece of work that is brought to them for litigation. This includes accusations, statement of issues, and petitions to revoke probation, as well as petitions for penalty relief and petitions for reinstatement. Once an accusation, statement of issues, petition to revoke probation, and penalty relief matter is submitted for board review, so that's you, then our client of HQE becomes the board. So up until that point, our client is Mr. Varghese. He's the complainant on every single piece of work that we put in front of OAH and that we serve on doctors. And of course, we serve Mr. Varghese, but he has excellent staff. He has Deputy Chief Marina O'Connor, and then the Chief of Enforcement, Charlene Smith, and their staff who are also managing every piece of work. So throughout the process, as evidenced here in this statute, we're always considering public protection as required by 2229. The board specifically is not involved in investigations of the board, and this is clearly to delineate non-participation by this board on how doctors fare in the investigative process. And so there's fairness built into that. You are shielded from that, but that's why our client is the chief of medical board. And like I said, we work very closely with them. We meet every 2 weeks to manage disciplinary matters in their various stages, including non-adoptions and closed sessions. Whoops. Is that? I think that's it. Yeah. All right. So real quickly here, it is the intent of the legislature that we represent you and other clients. Business and Professions Code Section 2220 was codified in 1980. And so that's pretty much where things have become much more formalized between our office and Department of Consumer Affairs. Our DOJ legal billing rates, just real quickly, are the attorneys bill $228 an hour, paralegals $213, and analysts bill at $202. CIO investigators generally bill about $117 an hour, and HOA investigators bill at $171 an hour. As you know from your materials, the expert costs can range from $200 to $800 an hour, depending on specialty. And the Office of Administrative Hearings can bill $395 an hour. Real quick, with interpreters, those are paid by the agency. We engage in making sure that every single person has a fair shot at presenting not only their testimony, but also to defend themselves. And that is a cost borne by you. And court reporter transcripts at times are needed to be prepared. The moving party pays for those official transcripts, and the medical board pays for copies. In 1993, the Health Quality Enforcement Section was charged to notify patients at the conclusion of administrative cases initiated by patient complaint, as much as they could be identified. Our Attorney General, our AGPA is assigned and makes sure that any case that is marked as a patient complaint is sent a letter that tells the patient that they can provide a response that we then share with Mr. Varghese. We also assist the board with their complaint liaison unit, established recently by Business and Professions Code Section 2024.5, and that has been discussed in recent medical board meetings. And as shown here in this panel, 20 to 30 is different than other statements, statements relative to harm, which are provided to you. The Attorney General is in its 9th year of publishing performance metrics as required by the legislature. These annual reports are very detailed in each client's legal work managed at the Office of the Attorney General relative to accusations. And as noted in those reports, no meaningful comparisons can be made between clients given the differences in filing burdens, strengths of laws and regulations that each agency applies to its licensees and applicants. These reports also show how many cases are rejected or returned for more investigation to the Department of Consumer Affairs, as well as the number of hearings held each fiscal year, the number of settlements reached each year, and the number of default decisions reached each year, notwithstanding whenever the matter begins. So these reports figure out reporting of cases finished in that fiscal year and provides the data looking backwards, no matter when those cases started in our office. And that's for 36 clients, of which, like we said, HQE is privileged to represent 8. And this is a point in time for that relevant fiscal year. Of note, to today's presentation, not all clients are subject to the high filing burden that you are subjected to, and nor are the defensive actions as heavily litigated as they are for physicians and surgeons. While the focus of those reports is on volumes and timelines, one cannot forget that we want to bring cases to a conclusion as quickly as possible to protect the public. That report does not cover interim actions that the Health Quality Enforcement Section is actively engaged in. Those are the summary suspensions and other work that are very quick, that ultimately lead to accusations and hopefully surrender or revocation. Just real quick, the Business and Professions Code Section 312 statute applies to the Department of Consumer Affairs, and they too have annual reports for every single one of their clients. That was established in 2010, consistent with the Consumer Protection Enforcement Initiative, and those DCA reports are available to you as well. Here's a quick slide. I know it's very dense, but it just goes to show the different types of cases that you refer to our office on any given day. The medical board is who determines whether they're going to investigate a complaint, how they will categorize it, prioritize it. The medical board decides when and how to refer the investigation to HQE. And at the time of referral to the Attorney General's office, the medical board also decides whether multiple investigations are going to be collected into one accusation. So one accusation can actually have multiple investigations in them. So I know there was a lot of discussion about the number of accusations and all that, but the primary consolidated number is up to the medical board. But each accusation can have multiple investigations in it. The medical board determines the volume of work that comes to our office, the programs they support having us be involved in, as noted, and not all investigations will have DAG involvement. The types of investigations that have DAGs assigned are reserved for the most complex types of priority matters currently. Generally, DAG involvement has a positive impact on pleading preparation time and results in matters not being returned for more investigation. Investigations also tend to be closed much earlier, allowing physicians to return to their work if there is no basis to proceed. We think this is important, as many of us here at the Attorney General's office are also professionals, and having the weight of an investigation over your professional application of your license can be mentally burdensome. As noted already, our billings draw from the LSRF fund that you assign to us every year. You decide how much they're going to fund us for in the year, and we try to stay within that budget. But when we can't, we just let folks know in your unit. Every matter that you refer to us is legally reviewed. And we decide on whether or not to propose a matter for the filing by Mr. Rahis. I am engaged personally on several topics of matters that I want to see before we decline a prosecution. We have been pleased to be able to assist you in cost recovery of the billings made by the HQIU, experts, and HQE. This has had such a positive impact on the health quality enforcement section that you decided to recover your own costs to help fund your initiatives. For obvious reasons, when cost recovery is not neutral, time is of the essence for litigants in the investigations. And then later on, if there's a filing, time is of the essence for respondents to resolve their cases sooner, not later, with the fact that they could actually be liable for 100% of the costs expended. So thank you very much for doing that. Your own board materials at agenda item 6C and 6C14 shows all of our metrics for the health quality enforcement section. You've been reporting this since I can remember. And there's a standing medical board quarterly report description of all your data for health quality enforcement and how long it takes to do different things that we do on your behalf. So this is an important slide. I think it was alluded to earlier about what we do in this process. So we apply prosecutorial discretion. And like I already said, we review every single case, but what does that truly mean? It means we, as highly specialized folks in our unit, are reviewing medical records, we're looking at slides, we're looking at the expert opinion and trying to find where exactly that expert relied upon in that evidence and made sure they got it right. When experts are reviewing thousands of pages of materials and they're doctors and they're being asked to be in judgment of a fellow professional, we just want to make sure that we're seeing what they're seeing so we can support that opinion later in a filing and make sure that this is something that is sound, material, admissible, and credible. And as noted already, and I heard a question earlier, we review it with the eye of clearing convincing evidence to a reasonable certainty to prove the facts and the law that establish the causes for discipline in an accusation seeking disciplinary action against a physician and surgeon. So evidence that is unclear, unconvincing, or unreasonable is not going to make the mark. Yes, we are looking for things that are material and admissible later on. And we do want to know everything that there is to know. And we would like to hear and at least see interviews of people that we think could be really good witnesses at trial. we can't we can ask for the moon and the stars, but we can't get it all. But we will make sure that it's good evidence. This is our North Star. I think we can all have it memorized. And this applies to when it's at the Office of Administrative Hearings. They're, I think, as equally engaged in the important delegation that you give to them to hear the actual witnesses, hear from actual experts, and to execute the important mandate of justice and due process, etc. Assigned administrative law judges engage with Health Quality Enforcement Section DAGs and the doctor's attorneys in early and mandatory settlement conferences, as well as when the administrative law judges fashion proposed decisions after hearing for the board's consideration. The caveat I have to this is that if you have specific questions about the Office of Administrative Hearings, I'm not the person to answer them. I'm only here from my experience in working with them to make sure that your cases are heard effectively and efficiently and as quickly as possible. This is only based on my experience and that of my team. On their website, they have all of their information, and any further questions about OH processes could potentially be referred to them and maybe another presentation. But like I already said, they apply clear and convincing to a reasonable certainty, which is the burden that applies to your cases. They decide which evidence is material and relevant, and the admissibility of evidence, as well as the weight of the evidence on each side of the scales of justice. What does that mean? Well, that depends on credibility of expert witnesses, of our patients, and even the talents of each of the lawyers on each side. The medical board has relatively low default rates. What does this mean? It means that most doctors that receive an accusation from you are not going to give up right away. They're always going to be sending notices of defense to be able to have their day in court. This is unlike other client agencies, and I know so because I represent other client agencies. There's a very high rate of representation by counsel in your cases. It's very unusual to see pro pers, and pro pers meaning people that represent themselves. And generally, because of the work that this board oversees and the licensing burdens, the higher the specific educational and testing requirements required to obtain the license, the higher the burden should be. It's a property right. And applicants, on the other hand, so this is for the division of licensing of your office, applicants are not licensed yet. So if they choose to object to your denial of a license, their cases are decided on a preponderance of evidence. Why? Because they haven't earned the property right just quite yet. Similarly, probationers who have failed in keeping their side of the bargain and the decisions and orders for probation terms and conditions are also subject to preponderance of the evidence. Every time you put someone on probation, the first two words are revocation state. So you're saying this person should be revoked, but we're going to hold off and see if this person can meet their side of the bargain. And their side of the bargain includes $6,917 of probation fees every year. So we think people that want to go on probation understand all that. They understand they have to pay costs, but then they also have to pay you, the medical board, for the cost of monitoring them. So they're pretty serious about their rehabilitation, generally speaking, and they are successful, most of them, I would say. And like I said, if they fail, they're subject to a lower burden. Probationers also have the legislative right to seek to terminate or modify their probation terms and conditions. What does this mean? If something no longer applies to them or is overly burdensome, they can go into court within that time before their probation expires to modify, terms of their probation or to request termination of the probation. We represent you in those as well. And while they hold the burden, they can inform the Office of Administrative Hearings of all their hardships or their successes that no longer require certain terms and conditions. Probationers can also surrender their certificates. This is a standard term of probation included in all probation orders. So experts are clearly the crux of most, if not all, quality of care cases. We want the standard of care to be not super specific. We want it to evolve with knowledge of different modalities. That's why experts operating within the same specialty, having direct experience with what the doctor they're sitting in judgment of has performed in that particular case, we want to make sure that those are aligned, and how quality enforcement section staff helps prepare every single expert for trial. And we provide feedback to the medical board and the expert reviewer program on how we're doing. Generally speaking, experts should have 3 years of practice, medical practice in California. They need to be in the specialty of the licensee they're sitting in judgment of, active in the practice at the time they render their opinion, and have direct experience, not textbook experience, direct experience. And the active practice means 80 hours of direct patient care, or if you're in a clinical setting or you're a teacher at a medical school, 40 hours at least of direct patient interaction. So we're not calling in academics to give us opinions, and I think that is fair. Let's see. Sean, can you advance this on your end, or yeah, thank you. Believe it or not, the health quality, the medical board did not always have a statute of limitations. So in 2006, after a sunset review, and I know this is a common refrain, so whatever can be improved is, and that's why it's amazing that you have a sunset review, because we look at what we're doing, and if we can improve it, we will, and you do. So in 2006, following some pretty hard cases where work was not being done because there was no statute of limitations and things were taking too long and patients were being hurt. And I'm glossing over the legislative history real quick. The medical board has statute of limitations. Only 16 of 36 Department of Consumer Affairs clients have statutes of limitation. So it's good that we have this. We have fire under our feet. So HQE has a standing request to receive cases at least 6 months prior to the expiration of the statute of limitations to allow for a full review of evidence and to avoid a rejection of a case based on statute of limitations lapsing where the evidence still needs collection or further development. We ask for 6 months just in case there are things that would allow us to file the case that still can be done. So it's just the 6 months is to provide the expert more time, investigators more leeway to be able to ask the questions that maybe are missing that would lead us to filing an accusation that is fair. And that, but because putting the public on notice of an accusation and what a doctor, it's a very critical piece of information that's put out to the public. We want to get it as close to right as possible, and that's fair as well. I may not have noted this already, but I don't want to forget to say, I meet with Reggie and his staff every 2 weeks, if not more often. I meet with Carrie on a regular basis. What are we talking about? Quality control, expediting issues, expediting cases, and solving problems. New things come up all the time, and that's what makes the job so exciting, actually. And we're just trying to get it right. But of course, all enforcement outcomes are impacted by the quality of evidence. And so that includes recency of witness testimony. It's always going to be stronger to the events in question. We have very limited discovery, and that's by design. The Administrative Procedures Act was created so that folks didn't need lawyers to be able to litigate these cases at the Office of Administrative Hearings. It is by design a very expedited process. And what does this mean to you? Well, it means we have very limited discovery, health quality enforcement section. The cat's out of the bag by the time we're sending that discovery. They know everything we know because everything that was collected during the investigation when the doctor and his lawyer have been interacting with the investigators at subject interviews and producing medical records, they know what they're sending. They know what they said. When we get that information and make a decision to propose back to Reggie to sign an accusation because we think we're ready to go, the discovery is pretty much developed. The only thing we don't know in health quality enforcement section is what defense expert are they going to hire? That comes pretty late in the game, and you've made some marked improvements. We get to find out at least 90 days before hearing who the defense expert is going to be, and this is 90 days before the originally set hearing. We would love to know sooner, but certainly doctors don't want to hire experts if they don't need to. If they can resolve a case, they will. Or if they're convinced by the expert that the medical board has, then they're done. We have very limited discovery. So what does that mean? We don't get to depose people. We have some interrogatory, but we're not running out and getting more documents. But if we do, we rely on Ms. Whitley's staff and team of professionals to go get more. But it's not to file, it's to refine at that point. So if we can't find a witness anymore, they moved, they go find them. If we see something said in the discovery that's sent back to us, we'll touch base with that investigator. And the really rewarding thing is if the investigator is still there at HQIU, who initially performed the work on the case, they get assigned that same investigation to go get that information. Investigators, as Ms. Whitley has said, they're shielded from the referral and the decision-making of Mr. Varghese. And so they're very, very committed to continuing the investigation where needed. If we file a case with conditions, what that means is we're going to file the case. This is a very important case. The public needs to know that this doctor is an issue. We can file that case, and then Ms. Whitley and her team can go and get a little more information, and we can amend that accusation to add in more. So don't think that we just throw up our arms or don't work all night, even when cases come in right before the statute of limitations has expired. Ms. Alvarado here and Mr. Kim, two of my SDAGs, almost every single person in the team, but I'm remembering them because they're right behind me, they have spent sleepless nights figuring out how to file accusations themselves. They're not assigning this work. They're taking the thousands of pages home, reviewing them, and getting this drafted. And it's a team effort. This thing's on fire, and we just get it filed. Yes, it took 3 years, but it got filed. Or not 3 years, 2 years and 364 days. For filing it at 3 years, we screwed up. So that's no good. These are all the things you never see here as a board. You don't see the withdrawals, you don't see the defaults, you don't see the automatic revocations, and you don't see the surrenders. Those happen outside of your purview. You get the hard work. These are things that are different, and they don't come to you. Settlement. When we charge accusations, it's ostensibly a one-sided presentation of allegations. Okay, so this is our view of what our case is. And so discovery, meaning when the respondent sends us their discovery that we haven't discovered in the investigative process, and they send us expert opinions, then this further assists the board in weighing the potential outcomes of a case and the materiality and relevance of evidence. We see it through a different prism. We deal every single day with your team of Mr. Reggie Varghese, Marina O'Connor, Charlene Smith as settlement contacts. We discuss factors with them that we're finding out. It's a very formalized process, and I'm involved on certain types of cases to make sure that it's more consistent than not with what the expectations are of the case. And it's actually a very collegial discussion with the legal team to make sure that we're putting the strongest evidence in front of our client so that they're fully informed before they make these decisions on giving us authority or not to try to seek a settlement of the case. Our clients push back. If something is too weak, they will add more. They say, no, we're not okay with this. We want you to add this term. We want more years, or heck no, you're going to hearing. And that's great. And that's fine because it is your case. And like Ms. Whitley said, we're very deferential to what it is that you want in these cases. The disciplinary guidelines establish violations rather than charges. So the charges and the accusation are not always what we can get at the end. Because remember, I just said, there's discovery that's sent over that we weren't aware of that does impact how we see the causes for discipline that we pled. Hearings are great. We like doing them. The Office of Administrative Hearings is very fair to respondents. They will allow them to present multiple expert opinions based on topic or patients. So in a 5-patient case, they could have 1 expert per patient, or if there's different topics in a case that they can hire the anesthesiology part of it and the surgeon. Sometimes we're outgunned, but we still get the job done. And I'm really proud of our team. HQE at times has to ask for special permission to hire new experts or additional experts in extenuating circumstances. We can only do so when they don't run afoul of the expert exchange deadlines, which are based on the originally scheduled hearing date. If we are past the 90 days before that originally scheduled hearing date, we can no longer get a second expert. And that applies when our experts have sometimes passed away. So it's very unfortunate. And the Office of Administrative Hearings will also give respondents their due and consider them experts as well. So like I said, we can be outgunned, but we still get the job done. As of 2006, this is great. Also following a sunset review, the Office of Administrative Hearings has specialized hearing panel only for your cases and for medical quality cases. And Ms. Webb is intimately involved in that training of those ALJs. So what this means is that you're not just getting a judge that just picked up a veterinary board, well, actually that's a bad analogy, picked up a contractor state licensing board case or a small appliance repair, and then all of a sudden they get a doctor case. There's none of that shock. They're very knowledgeable. They ask questions of the doctor. They ask questions of, they're very active in getting to the evidence that they need to hear. And you're very familiar with what they write. So hearings can last up to 2 weeks. We like going to hearing. At times, unfortunately, cases can be bifurcated. People sometimes need more time. And bifurcation means we carry it over for another day. We don't like that, but in any event, it happens. And like I already said, thank you for reinstituting cost recovery into your cases. We think it's a vast improvement. Now, with respect to time, any time that is spent considering a STIP or considering a proposed decision is added to the enforcement timeline. So all that time is added in. And it's your right, obviously, to make sure you get it right. And if things are remanded back to the Office of Administrative Hearings, so we have a STIP, the STIP is non-adopted at a closed session, and you ask us to go to hearing, that is all the time that it took to do that is encapsulated into the enforcement timeline. So it does add time. So this is something you're super familiar with. I don't want to spend too much time on it. So you know what actions you can take on your own accusations. And actually, yeah, let's see. Yeah, there you go. As with other things, whenever the respondent is the one needing more time and they go into a superior court objecting to your decision, The time it takes to writ, appeal, all that is part of the enforcement timelines and the averages that you produce. So if after appeal or a writ, the Superior Court thinks that you didn't get it right, you're the only folks that can actually institute the decision and order. So they sit in judgment of this, but they cannot do it for you. So it has to come back here for you to come to the same decision, correct it, or send it back to the Attorney General's office to go to hearing on to hear and take new evidence. And so, like I said, that's all factored into enforcement timelines. The board generally will not seek review of its own decisions, except in extenuating circumstances, which are extremely rare. And so pie chart in your agenda item, the pie chart is a nice improvement of Derek Hoff, I think is his last name. So that's a new thing. I think the pie chart is really cool. It actually explains every single cost related to every single thing that HQE does on your behalf. About 60% of our legal work is accusations. The other 40% is everything else. And everything else is substantial and important. Doesn't get discussed a lot, but it's critically important. And it includes the collaborative model. As noted every quarter, pie charts are in your materials. These are at 69. If you wanted to see more information on the types of work, and 6012. And like I already said, we pull from our legal services reserve fund to bill you. And so those are all the references that you guys can look at your leisure. It's a pleasure to have presented. Do you have any questions?
Thank you, Ms. Castro, for that comprehensive presentation as well. It's been quite some time since we've had an overview, and I think it was really helpful to have HQIU first and have you, especially for our new board members, but also very much for me and the others who've been here for a long time as well. Comments or questions? Dr. Yip?
Thank you so much for your effort and the team's effort too. A very good review. And question on the slide for prosecutorial discretion legal review. And it's probably 15, 20 slide back. It quote, review every case under the pressure to place the public on notice of physicians' alleged shortcomings. And that means before settle, before went to hearing, how does it work? Is it you post it, public can
Yes.
find it, and
Pleasure. So that part of the process is we receive the case from the medical board. So we use various modalities to do that. All the evidence comes over in a handoff sort of presentation. So handoff means the Deputy Attorney General was not involved in the case. We're seeing the completed investigation for the first time. And it could be thousands of pages of medical records, obviously reports of investigation written by the Health Quality Investigation Unit investigator, listing all the properties, all the witnesses, everything. DAGs should not and do not investigate the cases, but we critically analyze the evidence collected. It's that part of the process that is the prosecutorial discretion part of it. We're analyzing the evidence to make sure it's admissible, it's material, it's relevant, it's something we can use. But we're paying special attention to the expert report. The expert report is critical. The expert report can say there's extreme departures, there's simple departures from the standard of care, but we want to see what the expert saw and make sure it's there, and make sure that the type of evidence that they relied on is not biasing, that it's evidence that is reliable, and that it's not hearsay that we can't, that is not the type of hearsay that we can't overcome. And that can be presented through a testimony of a witness or a presentation of a document that says what it says. Now, the part of the prosecutorial discretion that is under pressure is, after reviewing this bulk of evidence, deciding which causes for discipline meet this high standard of presentation and accusation in order for Mr. Varghese to sign the accusation. So Health Quality Enforcement Section does not file anything. We draft the accusation and we send it to the medical board. And the medical board does actually do a lot of careful review of what we're saying, how we're saying it, how much information is in there, how patients are, their privacy is being protected, as well as doctors. You know, the mental health of doctors is a type of case that requires extra sensitivity for prosecutorial discretion. Application, we're putting the public on notice of something not only that affects the physician from a mental health or substance abuse perspective, but also we're reliving the worst day of the life of a patient or a patient's next of kin. So we're being sensitive about how this information is being presented and applying that discretion to decide which causes for discipline meet the high standard. But like the statute says, they're presented to you and there is a give and take. And so the same discussion happens when we decide not to recommend something for filing. These are some of the discussions that I will have with Mr. Varghese and his team is, well, you rejected this case or you reviewed and returned it. How come? What's wrong with the case? Can we talk about it? And coming out of that discussion, even though they're not prosecutors, they're our client. And so we obviously want to hear what our client has to say. It's very rare that a client tells us, thanks, but no thanks. We're not going to file this case because they sent us the case in the first place to review it. But that can happen too. Laws change. Sometimes there's been another resolution, the person surrendered, or there's been other outcomes. So hopefully that explains it. But the prosecutorial discretion is
Right.
the sphere of the AG.
I think my question is that when you read the place of public notice, before anything, sounds like the public can go to the site and look at
Yes.
every day who's being investigated, who's in the process.
Thank you. What that means is the way that the Health Quality Enforcement Section assesses every single case that comes over, we don't see a case. We see the patients that are still seeing this physician, that have no idea that there are concerns with this physician. And so we're in a hurry to be able to get that accusation to Mr. Varghese so he can sign it and he can post it on his website, Breeze. And it is our hope that patients look up their doctors, right? And so that's how we would see it.
Just for clarification, that becomes public when the accusation is filed, and it does not become public during the investigation process.
Correct.
Before an accusation is filed.
Sorry for the lack of clarity. Yeah.
Any other questions, comments?
Sorry, one more question is that the ISO go to the OAH and for certain like misconduct, severe bodily injury, what is the time process? You know, in movie,
it's very fast.
Knock on the door, the judge, they get you subpoena the same night. What has been the process? Is it something you can get it quickly?
Yes. So we're reviewing that evidence, and hopefully we're reviewing that evidence as close in time to when the facts that occurred. And so Government Code Section 11529 sets forth interim suspension order processes. And so an interim suspension is filed before the Office of Administrative Hearing on the most serious cases. These are cases of substance abusing physicians, very dangerous physicians that have a clear pattern of issues that place the public on notice. These are the types of cases that our clients are pulling out for collaborative model process. At times, also, the Health Quality Investigation Unit is reaching out to the client and saying, this seems like a super serious case. Can we involve the HQE DAG in it sooner? So we do have some joint investigations that we've been working on the last 5 years since the vertical enforcement program was eliminated. But when we're involved, we're definitely trying to triage that to make sure that if there's an interim suspension order that can be pursued by the filing of a petition in front of an ALJ It's a very high standard too, but it's a standard that is a civil standard of injunctions. So when we go in on an interim suspension petition, we're arguing that it's more likely than not that this person poses a harm to themselves or others if they're continued to be allowed to retain the license. If we obtain a suspension or a restriction, so sometimes we can't get a full shutdown, so the doctor has to stop working. If we're successful, the doctor stops working. If we're short of successful, maybe the doctor continues working, but if they're sex offending, they can't see the target of who they've been abusing. So they no longer can see female patients. Or if they're being mean to children, they can no longer see children under 18 if they're like a family practitioner. They can no longer work in an elder home because they're abusing older people. But within a very, very short period of time, the medical board has 30 days, other clients have 15. We have to file the accusation. Mr. Barhis has to file the accusation. But for the most part, if you're going in on an interim suspension order, you already know you're going to file the accusation, or at least you're hoping. And if an ALJ decides not to issue an interim suspension order, we're filing that accusation no matter what, as soon as possible. So I hope that answers that question.
Because the sentence read, ISO are decided by OH, ALJ, and are not brought to the medical board. Are there ISO that actually issued directly from?
Yes.
And then, but some case did go to the panel to vote on, right?
Yes, when they're accusations. So that's where you see in our, either in the proposed decision coming from OAH or in our STIP recommendations, we'll say this doctor has been suspended since we filed the accusation. So they've been suspended from practice for the last however long it's been. And that is also placed on your board website. The failure to follow a suspension order is the unauthorized practice of medicine in California pursuant to Business and Professions Code Section 2052. And that is a criminal matter. And so Ms. Whitley's staff is aware of that, and they have made referrals, unfortunately, for doctors they've discovered are continuing to practice when they've been ordered not to practice anymore. Yeah, I'm sorry I couldn't find the panel.
Other questions or comments? I guess I just wanted to double click on the clear and convincing evidence standard, just to remind us that we tried to get that changed. You mentioned during your presentation that other boards have a different standard. Could you just talk to us for 1 minute about who has that different standard and what it means that we have that very high burden proof?
Well, first of all, California has among the highest burden in the nation. So when we compare California statistics nationwide, it's apples to oranges. Kentucky has a preponderance. Other states do as well. So I'll start there. They can take a license much easier in other states. Here in California, the way that the case law has developed, the more time that somebody has spent getting their profession, which is a property right, the higher the burden is. So it is based on case law. And when the board valiantly put it before the Census Review Committee, you were trying to make sure that you were more on an equal footing with other state boards. So clear and convincing to a reasonable certainty is just a shade below beyond a reasonable doubt. And it's much higher than preponderance of the evidence. Preponderance of the evidence is 51% versus 49. Beyond a reasonable doubt, that's like 99%, right? It's like there's definitely this happened. You know, we don't need a video. All the testimony says this person killed that person. We're below that. So, but the evidence needs to be clear, convincing, and reasonable to a certainty. So it means it can't be unclear, no murky evidence. It can't be unconvincing. What does that mean? The defense expert didn't come in and eviscerate and tear down the building blocks of our expert. So it's convincing. This is what happens in the community of physicians. We're not applying the Stanford medicine. We're not applying a very low, we're applying the standard of care that it's the middle of the road. It's the Volkswagen. It's like what everybody, no matter who walks in that doctor's office, the community of professionals in that specialty has decided this is the middle ground. It's not up here, it's not down here, it's here. So is that convincing? Did the experts convince that ALJ, or will they convince them, right? This is why we do settle about 80% of our cases. Will they convince them based on the experts' qualifications and background and experience? How many of these things has that expert performed? How many laparoscopic surgeries has our expert versus their expert performed? Sometimes it comes down to that. How recently? Did they really do robotics? Where did they do robotics? Did they read about it in a book? They take a weekend course and figured it out? These are all things that are convincing or unconvincing to a judge. Reasonable certainty. Is it reasonable? Is this really what happened? Does it make sense? And are we pretty sure we got it right? Are you pretty sure, right? That this is what happened? And that's why it's such a rewarding thing to sit and see what happens to these cases. You are the client, you make these tough calls, and we do your bidding. So if we have to go to hearing, we will. And then you'll see the case again as a proposed decision, and you ultimately have the authority to figure out what's right and whether this person deserves rehabilitation or not, because the public will be harmed if they continue working. So I hope I explained that, but it's a very high burden.
Thank you. Dr. Yip, and then let's go to the public, please.
So that's the one I was going to ask too. You have the most experience in the room. What if we can lower the standard by legislature? What % of those licensees would be licensed revoked rather than put in probation?
That's hard to say. It's hard to say. Yeah, I don't know. Yeah, none of my clients have that standard. I'll say that. So I really truly don't know. But yeah, the evidence is more likely than not versus very high.
All right, let's open it up for public comment. For those in the room. Come on up. It's fine.
See, there. My name's Wendy Connect, and I want to make sure I heard this right. I think the words that Ms. Castro used after she said a doctor's given probation, the next two words are immediately stayed. Is that correct?
I think it's revocation, immediately stayed.
Okay. And then I think the conclusion was that, oh, they're given like $6,000 plus a fine for every year that they're on probation. And that would be and her conclusion was that would be a deterrent for, or an incentive for rehabilitation. I just think that that doesn't make any sense. I'm just going to say that that policy doesn't seem to serve the public. In my case, I'm fairly well connected with other doctors in this community. And when my doctor was given 3 years stayed probation, I know for a fact that other patients were harmed. There's one patient right now in a rehab facility for brain damage that he incurred when he bled out during a procedure that this doctor did while he was on probation. So is there oversight when a doctor is on probation? Because I just noticed that his probation was, his period is just over, and it was signed by you last month. And during his probation period, he was still harming people. So maybe this is a policy you need to relook at, because it's not really working to serve the public.
So thanks for that comment. I know this is not a back and forth, but probation monitoring is not under HQE, so that's separate, and perhaps we should have a separate presentation on probation monitoring also, but that's not something that the Attorney General's office is responsible for, but it's an important part of our process as well. So perhaps at a upcoming meeting, we can have some more information about how that works. Yeah. Fair enough. Any other comments from those in the room?
Good afternoon, Marcus Friedman for the Consumer Protection Policy Center. Going off the previous testimony, I know that it's a little off topic when it comes to probation, but it's something for this board to consider that when the revocation is stayed and there is a violation of probation, I understand that some of the numbers I've seen recently shows that the violation of probations, usually probation would just continue with a warning. So it would be interesting to know how many times probation is violated and whether or not that revocation of license being stayed is enforced or not, especially by the end of the probationary period. That's all my comments I have on this one. Thank you.
Thanks. Additional public comments from the room? Sean, can you open it up online?
Yes, if you'd like to make a public comment here on agenda item number 17, please do so by raising your hand now. First up here, we have Monty Goddard. You should be receiving that prompt.
Morning, Goddard again. I now wish you a good afternoon. I appreciate the very informative health quality enforcement presentation and board discussion. I appreciate this opportunity to ask HQE the same question I first asked HQIU shortly after the board published its transformative 2023 prescribing guidelines. Have HQE deputy AGs and staff been trained on the guidelines, since they are a significant shift from the MBC's medical board's infamous death certificate project approach? In my opinion, actual meaningful effective training is required to counter the systemic culture created by years of the board's infamous death certificate project. I hope someday I have the opportunity to ask the same legitimate question of the Office of Administrative Hearings. Everyone involved in disciplinary actions resulting from physicians treating patients suffering from severe chronic pain must understand the content and the intent of the medical board's much improved prescribing guidelines. The sad fact is, to date, the updated prescribing guidelines have not achieved their goal of encouraging physicians to return to the practice of treating innocent patients suffering life-altering pain. Physicians, quite frankly, are afraid to treat these patients. Thank you.
Thank you for your public comment. Next up here, we have Eric Andrews. Should be receiving that prompt.
Hi, can you hear me?
We can. Please go ahead.
I have been monitoring this board and thus the AG's office as a patient safety advocate for almost 10 years. I've watched board members come and go, but a few of us long-term advocates are still here, still calling this board out for its failures. To the new board members especially, pay attention to what I'm about to say because staff won't tell you any of this. Christina will tell you the exact opposite and call me a liar. I have proof. The proof is easily obtainable if you really want to see it. Do you, or are you just here to pad your resumes? First, remember that we've tried to change the burden of proof, and the California Medical Association has done a good job of making sure that doesn't happen. The AG's office is one of the biggest failures in this system, and I'll concede that in a small part that's due to how our laws are written. But what I've watched Gloria do meeting after meeting is spin the AG's office record with true used carsman salesman lawyering, kissing staff's ass and making it look like they actually care about patients. Here's what caring actually looks like. Board member TJ asked Gloria directly for documentation and clarification on specific issues. She couldn't answer, and then she disappeared from the meetings for 2 years. She's back now, smiling like nothing happened. I don't believe she ever provided what TJ asked for. Does anyone here know if she did? Because I don't. And there's worse. I watched Judge Catherine Feinstein, a former board member, take Gloria to task at a board meeting over a DAG who failed to act in time, causing a case to be thrown out because of his delays. Gloria acted like she'd never heard of it. She said she'd look into it. I asked about it at multiple subsequent meetings. She never came back with a single word about that failure. Judge Feinstein ultimately resigned from this board because her personal ethics were higher than this board's standards. That's in her resignation letter. Read it. The North Star Gloria talks about has been obscured by fog for a very long time. What the AG's office actually does is pick and choose when law applies in favor of assembly line production, clearing cases off their desks while they wait for their paychecks and pensions, something that victims they're supposed to represent can often no longer do because they're dead at the hands of bad doctors. The AG's office is at least as culpable as the medical board in the failure to discipline physicians, probably more so because they barter away board's own minimum disciplinary guidelines just to close files faster. That's not always considering public protection. That's doublespeak. New board members, when you go to the closed session hearings, listen carefully to how Dags and Carrie Webb try to strong arm you into protecting the doctor over the victim. Pay attention. Staff attorney Carrie Webb has been caught lying multiple times. I have the evidence. Don't believe her just because she's a medical board lawyer. Lawyers are wrong in court all the time. She's good at protecting the board, very good, but that's her job, to protect the board, not protect patients. Remember that when she tells you something, and then look it up yourself. Use AI for help. On January, am I out
Please
of time?
conclude.
Okay, I'm done.
Thank you for your public comment. Next here we have Rob Gordon. Rob, you should be receiving that prompt.
Great comments, Eric. Thank you. And thank you to the other patients advocates. Again, I am not a patient. I am not a doctor, but I have seen this. I have extensive knowledge because I have seen this whole process, everything with your investigations, with your Office of Administrative Hearings, everything. I have seen the whole process and trying to figure out what went so horrendously wrong with my case. I've done extensive research. I know the history. I know many things. I studied power. There's an important tenet of power. Knowledge is power, but power decides what knowledge is permitted. We see that extensively here. My comments now are going to be exclusively for the Attorney General's office. I believe it was Ms. Castro. I'm using as my point of contact Matt Davis, who was in the he's a supervising district, I don't know the exact title, supervising DA for that office. He's been professional and he's been responsive on freedom of public records requests. But you said yourself, your client here, the Attorney General, Rob Mont, is supposed to represent all the citizens of California. He's supposed to be the citizens' attorney, especially people like me who can't afford an attorney. But in this case, and you said it yourself, you are the attorney for Reggie Varghese. So I don't have such a thing. I don't know how it works. Do I get the trade? Do I get the Attorney General of Arizona or something? Or I think it's just tough noogies. But somewhere along the line, I'm launching a citizen investigation. Somewhere along the line, I know where it started. It started with Reggie Varghese. You guys conducted a full-blown character assassination and smear on me. Full-blown. Mean-spirited, filled with lies. And that was at the Office of Administrative Hearings. Now, if I had some of your investigative tools, I'm looking at language. I have a suspect of who wrote that. The judge, I forget her name, judge signed it. It's like a prosecution case. So they were prosecuting me. But I want you to know that is open. You attacked me, and I had no rights. So I'm just putting that on the table. Now I'm just letting you know that again, your office has been very professional, but I'm just letting you know that it's adversarial. And if you think I could get an attorney, go against armful, boatloads of government-funded attorneys, I cannot. So anyway, I'm fighting in the public realm.
Please
And
conclude.
the last comment that was made about me, that was very expensive. So I'm just leaving that as open. If I'm allowed to make
Your time is up.
Thank you for your public comment. Next up here we have Marion Hollingsworth. Should be receiving that prompt.
Okay, can you hear me?
We can.
Yeah. Good afternoon. Now, I'm Marion Hollingsworth, patient safety advocate. I'm sorry, but the presentations by the HQIU and the AG's office have just reinforced how little you all consider the patients in these complaint cases. Hearing that cases take 2 years before they're considered a priority was bad enough, but hearing Gloria Castro claim that investigations are, quote, mentally burdensome to the doctors is totally inexcusable. Do you realize how mentally burdensome it is to realize a doctor killed your loved one and that they're still practicing while you take 3 years to investigate and then possibly drop a case? This comment is so insensitive and dismissive of what the harmed patients and families who have lost loved ones go through, have to endure while you take your sweet time in investigating a case. What the doctor goes through is nothing compared to the heartache and anguish the families endure. It's an insult to the families to hear the AG's representatives say that. It's like saying the bank robber who shot a guard was upset when he was questioned by the police and that we should all feel sorry for him and what he's going through. You all seem to forget that you represent the consumers of California, not your private interests like the CMA, who seems to successfully influence many of your decisions, or your personal friends who come before the board with cases. You don't represent the doctors. Ms. Lawson recently said it was the board's duty to protect the profession. This was about 1.5 years ago. That's wrong. Look at this board's mission statement. Really look at it. It says nothing about protecting doctors or the profession or feeling sorry for them. I have tried my best to support your system of enforcement, but today proves that all you consider is the reputation and income of the doctors. It's shameful that this agency and the State Attorney General's office would dismiss consumers in this manner. You should hold yourselves to a higher standard or leave the board so someone else can do a better job. And as Eric said, you should remember that Judge Catherine Feinstein left this board after just about a year because she said her bar was much higher than yours. Look up her resignation letter if you care to emulate her example. And while you're at it, readjust your own bar. You should do better for the people of California. And I'm not giving up. I will keep holding this board and the doctors accountable, if nothing else, to shame you. Thank you.
Thank you for your public comment. At this time, there are no additional questions here.
All right, thanks, Sean. We'll bring it back to the board. Any comments, questions? All right, seeing none, Gloria, I'd like to thank you again for being here, and thanks to the other members of your team for joining us as well. We really appreciate it. Okay, we're going to move on. Agenda item 11, updates from external stakeholders. First up is an update from the Department of Consumer Affairs. Lucia Saldivar.
Hi, good afternoon. Can everyone hear me okay?
Yes.
Perfect. Good afternoon, board members and staff. Happy Friday. My name is Lucia Saldivar, and I'm the Deputy Director of Board and Bureau Relations at the California Department of Consumer Affairs. Thank you for the opportunity to join you today to provide some updates from the department. I wanted to start by extending a warm welcome to Board Member Portillo and Board Member Holmes on behalf of the department. We look forward to supporting you as you begin your service to the board. We are also excited to share that Chief Deputy Director Christine Lawley has been named the Acting Director of the department. She enters this role following the retirement of Director Kimberly Kirkmeyer. Director Lawley brings extensive experience to the position, having served in multiple leadership roles within the department since 2013. She will lead DCA in this position until a director is formally appointed by the governor's office. And shifting gears, last year, Governor Newsom took action to assist licensees affected by the Los Angeles fires and swiftly issued an executive order to allow 1-year postponement of license renewal fees that were due for renewal between January and June 2025 for survivors impacted by the fires. Last month, DCA began sending notices to licensees who chose this postponement option, with a reminder about the 1-year postponement and renewal fee due dates. Licensees with license types in the BREEZE system can pay these renewal fees through their online account. Those with license types not in the BREEZE system may submit their payments via mail. Also last year, Governor Newsom's proposed state budget included a proposal to split DCA's oversight agency, the Business, Consumer Services, and Housing Agency, into 2 new state agencies. the California Housing and Homelessness Agency, and the Business and Consumer Services Agency. After public hearings and review by the Little Hoover Commission and the legislature, the governor's reorganization plan was approved on July 5th, 2025. The new Business and Consumer Services Agency will be responsible for consumer affairs, licensing and enforcement, and the Department of Consumer Affairs, which will be among one of the 8 departments in this new agency. The 2 new agencies will officially become operative on July 1st, 2026. DCA continues to participate in multiple agency workshops and work groups on the logistics required to transition to the new agency, and will continue to keep the board and bureau leadership apprised throughout the months ahead. Additionally, to best serve the public, it is incumbent upon all of us to ensure that we are being fiscally prudent in our decisions, especially when traveling for board business. So DCA would like to remind members and staff to book their travel in advance to secure the best rates, and evaluate if a rental car is always necessary versus rideshare services. Carpooling is also highly encouraged when renting vehicles. We know that there may be some new travel costs for board members, such as baggage charges, so please keep receipts to ensure that you can be reimbursed. DCA also wanted to provide a reminder about Form 700 Statement of Economic Interests filings for board members. These forms must be filed within 30 days of assuming or leaving your appointment, and annually by April 1st. This year's annual filing period covers the prior calendar year, which is January 1st, 2025 through December 31st, 2025. The deadline for filing is Wednesday, April 1st, 2026. To ensure compliance, DCA requests that Form 700 filers complete the e-filing by Friday, March 20th, 2026. DCA board members must file these Form 700s through the FPPC's online portal. Paper filings will not be accepted. You should have received an email from the FPPC with instructions on how to file your annual Form 700. But if you have any questions, please contact Board and Bureau Relations at memberrelations@dca.ca.gov. And also some training updates for board members. DCA's training unit has developed unconscious bias training specifically for board members. This training will be added to members' learning management system, or LMS accounts, and incorporated into the onboarding process for all newly appointed board members. Also, board member orientation training, known as BMOT, is an all-day virtual training that DCA will offer on April 1st, June 24th, and October 21st. This training must be completed by board members within 1 year of appointment and reappointment to the board. Please register for the first available date to be in compliance, and board members can register for BMOT using LMS. Once again, if you need any assistance with accessing these trainings, please contact us at memberrelations@dca.ca.gov. And to close, I want to thank all of you for your dedicated service to protect California's consumers. I appreciate your time, and at this time, I'm happy to take any questions.
Thank you very much. Any questions? All right. Seeing none, I think our next update is from Ms. Whitley.
Good afternoon. So just a few more in-depth highlights from my previous just kind of overview. I just wanted to highlight that last month, our HQIU medical consultants all came together for their biannual statewide meeting. This is an important forum for collaboration and professional development with our med consultants. The meeting featured a presentation on the board's July 2023 guidelines for prescribing controlled substances for pain, focusing on how those guidelines apply to the complaint investigations and the role of the medical consultant. That training is a half-day training, so there was a large presentation on those updated guidelines. Additionally, our medical consultants received guidance and strategies to improve expert review outcomes by providing more effective case assistance. These sessions were very well received. It is so fun to be with our medical consultants when they get all together, because they don't get all together very often, and just seeing all of their collaboration and their excitement into talking about things is infectious. These sessions are always well received, and we'll continue to do those on a biannual basis. In August, our training unit successfully concluded its 2025 internal training academy that we call Mini Academy for all of our new investigators. This is, as I previously discussed, that intensive 4-week program to design to immerse our investigators in that specialized knowledge and skills that is required for our complex investigations. Some of those I just wanted to touch on again, just because of the public comment. We do specifically have a training course on investigating prescription drug cases, which includes the board's July 2023 guidelines for prescribing those controlled substances for pain. And so they go in depth about the differences of those guidelines throughout the years and the needed information and that they need to gather for those investigation types. Let's see. Again, we continue to make progress in reducing our pending caseload, specifically over our cases over a year, and that's reflected in our graphs provided. And that concludes my update.
Thank you again, Ms. Whitley. Any questions or comments? All right, seeing none, are there any questions or comments in the room? Sean, how about online?
If anyone would like to make a public comment on agenda item 11, please do so by raising your hand. First up here, we have Monty Goddard. Monty, let me send you that request.
This will be short and simple. Thank you to Ms. Whitley. That's it.
Thank you very much for your public comment. At this time, I'm not seeing any additional requests.
Thanks, John. We'll bring it back to the board. Any comments, questions? All right, we are going to move on to agenda item 13, an update on the licensed midwifery fund from Marina O'Connor.
Good afternoon. I have a couple in the handout. There is a couple fund condition slides, but I'll first go over and provide a little background, especially for the new members, and then I'll go over those attachments. So the board oversees the licensed midwifery program and carries out the licensing, cashiering, and enforcement functions for the program. The licensed midwifery fund is structurally imbalanced as expenditures exceed revenue and will need a fee increase to remain solvent. I'm going to provide some background on the fund, and then I'll go over the fund conditions and the attachments and the estimated fee increase. In fiscal year 14-15, the midwifery fund was appropriated $13,000 to pay for the cost of its cashiering, licensing, and enforcement functions. In fiscal year 18-19, the board requested an increase to the midwifery fund's spending authority by $107,000 to ensure it could pay for the licensing, enforcement, and cashiering functions performed by board staff, bringing its appropriation to a total of $120,000. The midwifery fund's appropriation has not changed since fiscal year 18-19 and remains at $120,000, even though program costs have increased and exceed $120,000. While expenditures have remained around $120,000, actual revenues received have remained under $100,000, creating a structural imbalance. Based on the recommendations of an independent 2020 fee study, the board sought a fee increase to the licensed midwife application and renewal fees, which the legislature approved through the board's sunset review process. Effective January 1, 2022, the license application fee increased from $300 to $450, and the renewal fee increased from $200 to $300. This fee increase was not enough to fully fund the program's operations, and the structural imbalance continued, and the fund is currently projected to be insolvent by fiscal year 29-30. The board must seek a fee increase to ensure the midwifery fund can pay for the full costs of its operations. So now I'll go over the two fund conditions in the meeting packet and up on the screen. The first one is the status quo, which is basically if nothing changed. The second is the midwifery fund with an estimated tiered fee increase. And both fund conditions are based on the governor's fiscal year 26-27 budget. So starting with the status quo, I'm going to try to use the pointer here. Oh, unfortunate timing. There, okay. So I'm going to walk through just a few things on this one and then the next one, and then we can go over questions. So, okay. Oh, which button is? Yeah, that's one. Maybe don't use the pointer. Okay, we'll skip the pointer. All right. So at the top, the first column, you'll see these are the 24-25 actuals. The first row is the funds beginning balance, which is 231. Sorry, it's a little hard for me to see even from here, so I'm hoping I'm getting this number right. There we go. Thank you. 231. What you see below that is an adjusted beginning balance. I'm sorry, a prior year adjustment of 48,000. Everything on here is in thousands. So that 48,000 is actually expenses from fiscal year 23-24. But what happens is because it's shared services, a lot of the costs aren't determined till the end of the fiscal year. And if they don't get processed before year end and year end's closed out, they get basically shown as a prior year adjustment in the following fiscal year. So that 48,000 was from expenses in the prior fiscal year. So after that adjustment, you have an adjusted beginning balance of 183,000. And then below that are the revenues from the license and renewal fees. And the total revenues for 24-25 was 98,000. And then below that, you have the total resources, which is just your beginning balance plus your revenues, which is 281. And then keep going down, you have your expenditures. So that first row, that 88,000, that's the actual expenditures for 24-25. But again, because a lot of the costs aren't determined until the end of the fiscal year, some of those costs actually show as a prior year adjustment in current year 25-26. And the total is 120,000. So it's at 88 plus the 32 you see in the next fiscal year is 120,000. Below that 88 is the statewide pro rata. So that's the cost of services provided by other state agencies to the midwifery fund. And then that 95,000 is the total expenditures and expenditure adjustments, which is 95,000. At the bottom is the fund balance, 186,000. And below that is months in reserve. So that's basically if the program stopped bringing in revenue, how many months could it operate on what it has in its fund. So going to the next column is current year expenditures for 25-26. Of course, we're still in the current year. So these are projections based on, I believe, sorry, Sean, if you scroll up to the top. Okay, it actually doesn't, actually, sorry, it's at the bottom. It's a footnote at the bottom. It's based on, well, it doesn't say on here. It's probably our most recent fiscal month of data, whatever we have by now, which is probably through December. So again, you have your beginning balance of 186, and then that 32,000, again, that is expenditures from 24-25 that didn't meet the fiscal year cutoff. So they're showing as a prior year adjustment in 25-26, and then an adjusted beginning balance of 154. And again, you go through revenues, total 89, again, that's projected. Total resources 243, expenditures 120, that's the full appropriation. We project them spending the full appropriation. 8,000 is estimated in pro rata, statewide pro rata, which leaves you with 128,000 in total expenditures. And then you see that fund balance at the bottom, 115, obviously is declining from the prior year. Months in reserve declining and so forth. You follow months in reserve and your fund balance each year thereafter. And we're projecting that it goes insolvent, which is the red. I know it's a little hard to see, in fiscal year 29-30. So this is, again, status quo. We don't do anything. Everything stays the same. And then, Sean, you can scroll to the next page, which is, again, the governor's 26-27 budget, but we've built in, and actually, shoot, it's hard to see on the slide here, but there's 2 rows where we've built in the estimated additional revenue from a tiered fee increase. Yeah, it's that one. Yep. That's the estimated additional revenue from a renewal fee increase effective in fiscal year 27-28. So it'd be January 1, 2028. And then that one is the estimated revenue from the license fee increase, also effective Jan 1, 2028. And then there's another fee increase built in for starting Jan 1, 2030. So the first fee increase would be 1,260. These are all estimates. Everything here is based on the data we have as of today. So obviously things can change as the years go on. Initial and renewal fees would be set at 1,570 in the second tier of the fee increase, beginning January 1, 2030. And Sean, if you scroll down to the very bottom, you'll see the projected months in reserve and fund balance. They are going down. And then when we have the fee increase hit right where that kind of shaded row is, the 2.5, that shows the first year of, trying to follow. Oh, no, prior to that, 27-28, that's the first year the fees increase. And that's a half year of the revenue because, again, it's in the middle of the fiscal year that the fees would increase. So that's just half a year of the additional revenue. And then the following year, 28-29, would be the first full year of that revenue increase. So you can see it starts to balance out about fiscal year 29-30 and would be estimated to remain pretty balanced because, as you see, the total revenue up top, if you look at starting in 27-28 where the fee increase takes place, it's 206,000, and then expenditures at the bottom are 120. And the other thing I want to point out is the following year in 28-29, you'll see an additional row in the under expenditures, that 250. So that's what we estimate to be the cost of that plus 120, I believe is 370. That's what we estimate to be the true cost of the program's operations. So you first have to implement the fee increase to bring in the revenue, and then you can seek an increase in the appropriation to charge the program the full cost of its operations. So the very bottom, you see it balances out a bit where your revenue slightly exceeds your expenditures. And we believe this is what's going to be necessary to maintain a solvent fund. I know that was a lot of numbers to go through, but obviously if you have any questions, I'm happy to take those questions. I did want to thank the DCA Budget Office and our budget manager, Derek Raw. Him and DCA worked a lot on these numbers, on making sure our cost estimates were as accurate as possible and to put together this proposal. So thank you.
Thanks, Marina. And just for the purposes of this meeting, this is an update. And at some point in the future, we're going to be, I guess, taking action on whether or not or how to seek that fee increase.
Correct.
Is that right? Okay.
Right. This is just an update. Yeah.
Questions, Dr. Tsai?
Yeah. So does that mean that currently we're subsidizing the cost of the program of the council, and then that is actually realized and expressly stated at 28-29 of 250?
Yes.
Okay.
Yes. And again, it's an estimate, but that's what we would estimate the cost to be at that point and ongoing. It's tough for this program because it's such a small program and it's such small revenue and small expenditures that there's any kind of little long enforcement case that goes out much further, or even just a slight increase in enforcement cases can really impact it. So that's what we think would be needed to maintain kind of the current enforcement the current enforcement caseload we see, to make sure that there's enough money in the fund to pay for that.
Okay, thank you.
Dr. Ayala Rodriguez.
Thank you so much. When we go to the ones in reserve, like in the future years and things like that, it does stabilize, but it does stabilize at one. And for example, one of the things that you, right, like it does stabilizing like 1.4 ones in reserve around that. My concern would be with that, with volatility, because if any change like affects the operational expenses, then potentially you end up like negative again. And I think that as we revise like that, what would be the ideal fee? We have to take into consideration the maybe not dropping the 3 months in the reserve and trying to keep it in around that. But
Yeah, no, absolutely. That's not much. 1.3 months in reserve. What we're trying to do is be as, understanding the impact this is going to have on the profession as well. This is quite a significant fee increase, which is another reason why we were looking at a tiered fee increase. And it's probably something we're just going to have to keep an eye on very closely every year, but it's not going to be perfect. It's definitely, again, because it's so small and can be so volatile, potential volatility. It's just as close as we can get, but again, taking into consideration the cost this is going to be, bared by the profession. So it could, that's another, just these are estimates based on today. If we pursue legislation on this at some point, this is years, right? I mean, obviously, we projected not actually charging the fee until 27, 28. So by then the numbers will all be updated. We'll have new information and it could change slightly, but this is what we know as today. This is what we're estimating based on what we know today. And I think we just are going to have to keep a very close eye on it.
Comments, questions, Ms. Holmes, excuse me.
Thank you. When was the last fee increase?
That was in 2022.
Okay. And what percentage increase was that?
Off the top of my head, I want to say it was like 150% maybe, or no, not that much. I'm sorry. I'm going the wrong way. Maybe 50% increase.
Okay.
Yeah.
And what is the projection of increase in expenses? What percentage? I think I'm teeing off of your question, Doctor, which is what's the model that you're using to cover the increased costs or aka even inflation? Right?
Yeah, we don't take into account inflation. I could tell you that. We also don't take into account the increase in the licensee population because it's so small year after year. It wouldn't have any real significant impact on what those fees would be. But basically, we're looking at what's the annual cost, and then we look at the licensee population, and they have a biennial renewal. So they renew once every 2 years, same as physicians, surgeons. So we basically assume about 50% of that licensee population is going to renew each year. So we basically took the total expenditures and divided it by half the licensee population to come up. The renewal fee is going to be mainly the renewal fee is and what will be what mainly funds this program. The application volume, which you may have seen in, the board meeting packet, is very small. So that's not going to have a huge impact on the fund. It's mainly going to be from renewal fees.
Right. So maybe I can ask it one other way, and maybe we don't know the answer. So program costs always increase. I mean, wouldn't it be lovely if they just went down, but they don't. So what, again, is the percentage that you've built in here for program increases over these years?
We didn't. So the 370 is conservative. Yeah. It is. But again, year after year, the more data we'll have when we actually come time for this proposal, it'll be a more accurate representation of what we think the fee needs to be. But it's just going to have to be something we watch very closely and work with the DCA budget office to make sure we're planning for the future and we don't end up in this situation again.
Thank you.
Other comments, questions? How about from the public? How about online?
Yes, if anyone's got a public comment here on agenda item number 13, please raise your hand now. I'll give you a few seconds to see if anyone queues up. Not seeing any requests at this time.
All right, thanks, Sean. We will bring that back to the board. Thanks, Marina. We will look forward to hearing more about that at a future meeting. Moving on to agenda item 14, update from the Physician Assistant Board, Dr. Sy.
Thank you, Madam President. As the ex officio member of the PA Board, because of the representation from the California Medical Board, I usually attend quarterly meetings. The report I'm about to give includes the November from last year and, of course, the recent held meeting on Monday. So in November, the PA Board meeting highlights included adoption of the Sunset Review by the legislature, the new project that they're going to undertake is to review and revise the practice agreements, compare and contrast with other states. As many of us are aware, physician assistants have a practice agreement with the supervising physician, and the PA Board announced that they would start looking into compare and contrast how California compares to other states. Other notable items was the election of President Mr. Vasco Kidd and Vice President Mr. Diego Nzunza. Currently, there are in November, there were about 19,000 PA licensed in California, and of the PA programs in the United States, 20 of the programs are in California with about 1,000 students a year. Moving on to February's meeting, which was held this past Monday. One of the issues about the big, beautiful bill that the president passed was it affects the ability of PA students to get loans as classified under the current tax bill. So the PA Board is looking into how to sort of resolve those issues and still encourage students, potential students, to pursue a career in PA. Other highlighted items include the current active licensees as of February is 20,000 now. They're interesting to note their current processing times for applications is 28 days, which is sort of similar to our processing times. Last year, they received 699 complaints. 41 of them was non-jurisdictional, which meant that they go to other agencies. Average age for pending case is about 400 days now. The current licensees on probation on the PA Board is 35. And so one of the interesting presentations that they had was the Professional Practice Agreements, PA Modernization Act, and I think that's something that we will be seeing at the Medical Board is a lot of the states are very progressive in the sense that PAs can independently practice without physician supervision, which is the collaboration model. Currently, California is a supervision model where a physician supervises the PA. In other jurisdictions, the PAs work collaboratively with a physician, which means that they will not need to be supervised. So I think quote unquote modernization of the PA practice in California may bring new issues to the Medical Board. So that's sort of on the horizon. And that concludes my report.
Thank you, Dr. Sy. Any questions or comments for Dr. Sy? Dr. Yip?
Any update on the percent of chart that the supervisors need to sign off or supervise?
I think currently for billing purposes, I think currently if you supervise the physician, you can charge for the full fee. Physician assistants, if they are not, notes are not co-signed, I think you get 80% of the fee, but there's no actual necessary requirement on how many charts you have to sign. And one of the physician modernization acts around the country is to advocate for independent billing from PAs.
Thanks. Any other comments, questions? Anyone in the room? Sean, could you check online? Sorry, I missed you for the second time this meeting. Dr. Ayala Rodriguez, and then we'll go online.
No, yeah, thank you so
You
much.
gotta raise your hand higher, I guess, or like
Yes.
flag me down.
Yeah, I believe that last meeting, like there was a comment about like maybe considering the increase of supervisees that a medical doctor like could do. And I saw like on the ABs that one of them like passed and it's like already 8.
Yes.
But do you know if like we were like part of that like communication discussion or anything like
No,
staff or anyone?
the previous physician supervision ratio was 1 to 4. In their sunset review, they increased it to 1 to 8, and the logic was to promote access to healthcare, especially in rural areas. And one of the forces behind this modernization is to provide increased access, especially in rural areas.
Thanks. Okay, Sean, do we have any comments online?
Anyone like to make a public comment on agenda item 14? Please do so by raising your hand now. First up, we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, hi, Dr. Sai. I was blocked from speaking last time about Dr. Christopher Gordon, who in the past had a problem with crystal methamphetamine. Now, they guessed, they speculated what I was going to say about them.
Mr.
And
Gordon?
they were wrong. They were wrong. I was
Are
gonna
you
say something
talking
positive.
about the
I'm talking about physician assistants. Now, when I'm interrupted like this, I lose my train of thought and I don't make, and I'll say something different. I'm talking about my physician assistant, and if I'm allowed to make my point here, I'm forgetting part of it now. But
Sir,
one of my
this is an
points, I've never
update on
met
the
him. I've never
physician
met my
assistant
physician.
board. Do you have a comment on Dr. Sai's update on his liaison?
I think never having seen a physician's assistant never having seen the physician that's
There are no additional requests in queue.
Sorry, no further comments online? Thank you. Okay, we'll bring it back to the board. Any further comments? Okay, thank you, Dr. Sai, and thank you for the extra time I know that it takes to spend on another board as well. We're going to go back to yesterday now, to agenda item 8, an update on the joint forum.
Thank you, Madam President. This informational item summarizes the outcome of the December 17, 2025 Joint Forum on Controlled Substances and Medications for Opioid Use Disorder, co-hosted with multiple California health agency regulatory boards. And I'm very appreciative of you taking your time to come and welcome the group. It was well attended in person and online. So the purpose of the forum was to strengthen cross-agency collaboration and address the systemic barriers affecting controlled substances prescribing and access to medications for opioid use disorder treatment. So key themes identified in the forum, there are 4 key areas I'm going to share here: communication and coordination gaps across regulatory entities and prescribers and dispensers, regulatory and operational challenges impacting prescribing practices, patient access barriers, stigma and insurance constraints, e-prescribing issues, pharmacy dispensing thresholds, and drug shortages. So what is the next step after this forum? Participating agencies are evaluating actionable strategies to improve interagency alignment, reduce administrative friction, and enhance patient access to appropriate pain management and opioid use disorder treatment. So the executive summary or takeaway is that the forum reinforces the board's leadership role in convening stakeholders to address complex, high-impact public health issues through coordinated regulatory engagement and system-level improvement. That concludes my prepared remarks. I'm happy to answer any questions.
Thank you, Mr. Varghese. And it was nice to be able to be there. And it was a very well-attended forum, both in person and then online as well. So thank you for the convening. Questions or comments from board members? Dr. Tolbert?
I was just curious, are there any next steps from that meeting?
Yes, we are. The committee met this month, February, and went over all the, again, we use AI to cut down on all the because there was like, I don't know, over 10 or so different breakout sessions where they discussed similar topics. So there were a lot of overlaps and duplicative remarks and suggestions. So we cut down on that. So the committee met the first time and identified the top 4 or 5 areas that we can work on. Again, categorized what is in our backyard that we can work on, what we need to involve in future forums. So more to come on that. I cannot promise any future forum at this point. Nothing's planned, but as that information comes forth, I'll share with the board. Thank you.
Other comments? Anyone in the room?
Hello, my name is Lucas Evanson, and I'm speaking on behalf of the California Medical Association. CMA appreciates the board's leadership in convening this joint forum and in recognizing the impacts its policies play in impacting prescribing practices. As we've seen, the board's actions can impact patient care. Patients with pain continue to report struggling to find care for pain management. As this work continues, CMA continues to encourage a balanced approach, one that supports appropriate oversight while also ensuring that patients have access to appropriate pain care. CMA looks forward to continued collaboration with the board to strengthen access to safe, high-quality care for patients across California. Thank you.
Thank you. Anyone else in the room? John, can you check online for us?
Yes, if anyone would like to make a public comment on agenda item 8, please do so by raising your hand now. First up, we have Monty Goddard. Monty should be receiving that prompt.
Good afternoon again. This is my only prepared comment. On behalf of my colleague, Pat Irving, and all of my pain patient advocates who attended in person or virtually, I want to personally thank President Lawson, Executive Director Rajesh, and all others responsible for co-hosting the all-day December 17th forum. It was great to finally meet Director Rajesh and Dr. Thorpe in person. Same goes for President Lawson and team members Carrie Webb, Aaron Bone, and if I recall correctly, Deputy Director O'Connor. Pat and I were invited presenters highlighting 3 important issues harming Californians afflicted with severe life-altering chronic pain. The issues are the Medical Board of California's 2023 prescribing guidelines, much improved, but as you've heard earlier today, with too little adoption, and the state AG's nationwide opioid settlements, injunctive relief disruption of the controlled substances supply chain to pharmacy shelves, and finally, insurance company business practices. Later in the day, I had the honor and pleasure of sitting on a panel moderated by then Department of Consumer Affairs Director Kimberly Kirchmeier. My 3 co-panelists, one of whom was the Board of Pharmacy President, Dr. O, were all highly credentialed, experienced individuals. All were very supportive of improving the plight of those suffering from undertreated pain. I want to share 4 on-point statements voiced by my co-panelists. First, I hope we come to some kind of a solution. Come to Jesus moment of how we can really help patients who need these medications, because definitely the way our current system is set up is not obviously putting patients first. Next, I think prior authorizations have to be figured out. We all want to help patients. We know who they are. And I think nobody wants to say, no, thank you, and move on. We want to help patients. So we need to help healthcare providers take care of our patients. We need to figure out a way. Referring to the injunctive relief, this comment, I don't know if it is helping anyone to be making lists of physicians who are prescribing opioids unless there's some issue with that, unless your goal is to not have physicians prescribe opioids, which I hope is not the goal. And last comment, the challenge and why we are here today is because this is not easy. The one-day forum was a great start in addressing the challenge of the current ongoing patient harm. My fellow advocates and I eagerly await the opportunity to engage in the forum's promised follow-on action items. Thank you once again for this remarkable event.
Thank you for your public comment. At this time, there are no additional requests in the queue.
Thanks, John. We'll bring it back. Any further comments? All right, thank you, Mr. Varghese. We're going to move on to our last agenda item for the day, future agenda items. Do any board members have suggestions for future agenda items? Dr. Yip?
It would be nice to, in the future, have a review on the surgery center, accreditation, survey, outcome, mortality report, complication, and because there are more cases that has been, there are more cases, intensity of the cases, or the level of the cases that are being performed in outpatient surgery center now. Thank you.
Bless you. Additional comments, Mr. Watkins?
Yeah, I just want the future agenda item report back about the notice to the public for doctors under investigation.
Thank you. Other agenda items? Dr. Sai?
Yeah, thank you, Madam President. As you mentioned, there's an interstate compact, and I think I would ask for a presentation on how that works and how it would apply to California.
Thank you. Other agenda items, Dr. Ayala Rodriguez?
Thank you. I think that eventually mentioning about the plan that we're going to have for AI monitoring, because it's like rapidly evolving, but like what is going to be our strategy? Like pulse check, like every 3 months, like what has changed over the last 3 to 6 months? Like, do we assign like someone specifically to monitor, like eventually like over like monitoring of it, like formally? Because I don't think that it's anymore about like who's going to use it. Like everyone is going to be using it some way, somehow. And it's definitely part of the medical practice that it's going to be happening. So like what's going to be our monitoring, like to a certain degree, like, and cadence of it. Then outside of that, I think that we briefly touched into the probation presentation. I think that the background, I think that that was like very good. The other presentations that we received, but I think that hearing more information about the probation processes, compliance, ramifications when there's violations and things like that, I think that that would be good. And just like echoing my comment about the maternal infant mortality, just like the follow up with the other stakeholders. It's like we do have some information from the licensees, but as a team of stakeholders that have a shared goal of improving like that particular outcome, like what can we do?
Thank you. Other, Ms. Torres?
This may already be on there, but I too wanted to continue the conversation on the maternal mortality numbers. I thought that was very fruitful where it was going, so I'd like to see that continued.
Thanks. Other agenda items? Okay, seeing none. Agenda items from those in the room?
Hello, good afternoon, board members. My name is Ula McPherson. I am a student intern for the Consumer Protection Policy Center, or CPPC. 2 years ago, the most recent enforcement monitor instructed this board on various major issues. While we heard some of those cost and timing issues from HQIU and the AG's office today, we have not heard from the internal process within the board itself, specifically this board's trend to enforce the minimum disciplinary guidelines at the time of disciplinary actions and lack of useful tools such as protective orders. At that same meeting 2 years ago, this board discussed that there would need to be changes made through the legislature to address these issues. However, as to our knowledge, there have been no legislative initiatives by this board to strengthen the enforcement process. CPPC would welcome future presentations at board meetings to discuss the internal issues in more detail. CPPC urges this board to take these issues seriously as this board is approaching its sunset review soon. CPPC would be open to collaborating on legislative changes to help address these issues as well. We believe the enforcement discussions over the last 2 years have not been strong enough to address these issues. The leadership of this board should use its time and resources to work with the legislature to ensure public safety is being met, specifically in its internal and board decisions. Thank you.
Thanks. Other future agenda item requests from the public in the room? Sean, how about online?
Yes, if you'd like to make a public comment on agenda item 18, please do so by raising your hand now. First up, we have Rob Gordon. Robbie should be receiving that prompt.
Yeah, I've got first thing, real quick, because I'll almost certainly be censored here, but a mistake that was made earlier was very costly. Now, real quickly, I do have an important point to make, and it's right in front of you guys. Just look at the room. It's empty. And you have been traveling around giving seminars or giving these, these meetings to empty rooms for the last year.
Gordon, you're not on topic.
Yes, I am. Isn't this future agenda items? Is this
You have a
future
request
agenda
for
item?
a future agenda item.
Okay, discuss the empty room, the horrific cost to taxpayers, and the selfishness that you have by going and giving a presentation to an empty room, expensive. Are you going to make me do like, records requests and make videos? I'm trying to do you guys a favor.
What's your
And not
future
make this
agenda
ugly.
item,
No,
sir?
that is my agenda item. I have a couple more. Now you have cost immense amounts of money. Can I make my last point? I wanted to make it. I will never have the opportunity to give a victim's statement or anything like that. You've effectively cut off communication here.
Here we got Michelle Montserrat Ramos. You should be receiving that prompt. Anyone else has a agenda or a public comment on this agenda, please raise your hand now. Go ahead, Michelle.
Good afternoon. I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Thank you to Dr. Yip, Dr. Ayala Rodriguez, and Ms. Torres. We agree and would like to see an update on the new maternal mortality task force, when update on collaboration with other organizations mentioned yesterday, and the status on information collection. Thank you.
Thank you for your public comment. At this time, there are no additional requests in queue.
All right, thanks. Any last minute future agenda item requests from the board? All right, our next item is adjournment. We will see you all for the next time in May in Sacramento, I believe. We will see you there. Thanks, everyone. Thanks, everyone who joined us here in the room.